Courtroom deputy. We're all, looks like everybody's ready to go. Why don't you call us all to order?
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, good morning, everyone. We're pleased to begin argument in our first case, Milligan versus Merrill Lynch. And Mr. Jasinski, we'd be pleased to hear from you in this.
Thank you, Judge Wilkinson, and may it please the court. My name is Matthew Jasinski, and I represent the plaintiff, Kelly Milligan. Congress provided two alternative routes to pension plan status. Route 1 appears in subsection little Romanet 1 of 29 U.S.C. 1002-2A, and it focuses on the type of benefit, namely retirement income. Route 2, subsection little Romanet 2 of that same section, is the path at issue today. It focuses on the consequences of deferring income without regard to retirement or purpose. Specifically, it provides that any plan, fund, or program that results in a deferral of income by employees for periods extending to the end of covered employment or beyond is an ERISA plan. The Supreme Court in the Barrage case explained that a thing results when it arises as an effect, issue, or outcome from some action, process, or design. So the question here is whether a deferral of income arises as an effect, issue, or outcome of the plan in this case. And that is the standard adopted both by the Sixth Circuit in Wilson and the Fifth Circuit in Tolbert. The undisputed facts demonstrate that Merrill Lynch's wealth choice plan results in exactly what the statute describes. First, Merrill Lynch pays financial advisors based on their productivity. Their compensation is calculated pursuant to a formula that awards financial advisors a percentage of the revenues and fees attributable to that advisor. Second, Merrill pays a portion of the advisor's annual productivity compensation, which I just described, as monthly advances, what the district court correctly described as commissions. But each year, Merrill requires financial advisors to defer the balance of their production compensation.
Let me make sure I understand at least the nature of this plan. It sounds like you're describing something I didn't attribute to being the wealth choice. As I understand this, and correct me if I'm wrong on it, but as I understand this plan, nothing vests in this plan until after 8 years, and there is there's nothing that's paid in this period of time. You call it deferred income, but it really doesn't become income until it vests at some point in time. Is that right?
I know I wouldn't agree with that, Your Honor. I think that's sort of the question in the case, because if ERISA applies, then the question is what length of vesting period is allowed, because ERISA, of course, says that if you have enough years of service at the company, then an employer cannot condition your receipt of income.
But I'm just looking at the text of this. Judge Wynn asked the precise question that was on my mind. How can this be a deferral of income? I mean, and just sort of concentrating on that word deferral. If they're not entitled to the income, you can't have a deferral of something that you're not even entitled here. They're not entitled to anything until they meet the conditions of the award, which is 8 years down the road. And then when they meet those conditions, then the funds are awarded them. But that's not a deferral. It's something that they receive once they're entitled, and that's after the 8-year period, which normally falls prior to retirement. So I don't, when you look at the text of the statute, and I think it's really a textual question, I'm just not sure how there's a deferral here if if nobody's entitled to the income. You can't defer something that you have no right to receive.
Judge Wilkinson, I agree that is the question. And so Merrill's defense fundamentally relies on the notion that financial advisors have not earned their deferred compensation until it vests. But by defining earning and vesting to mean the same thing, Merrill Lynch essentially tries to evade ERISA entirely. Because if you simply say you're not entitled to it because you don't get it for 8 years, then you have given license to every employer to condition payment on how long they're at the company. The very thing that ERISA was intended to do with the vesting requirements is to say that an employer may not do that. An employer may not say that you have to stay here.
How can you defer something which you can't receive? If the employee may want the income, he or she may want it now, but if you can't receive something and you're not entitled, you're not deferring anything, are you, until the entitlement kicks in after the 8-year period? I just don't understand. There's some textual problems that concern me, and one is how we fit this within the notion of a deferral, and number two, there's a problem about extending to the termination of covered employment, because I'm not sure that that this whole scheme extends anything to the point of the termination of employment. It does maybe incidentally in a small percentage of cases, but we have a finding of fact that the district court made that something like 92% of these benefits are received prior to employment, prior to the termination of employment, but while the people are still actively, while the plaintiffs are still, or the recipients of the financial advisors are getting this well prior to retirement, not in every case, but in most cases. And I always thought that when somebody, and this is just sort of my connotative reaction, but I always thought of a pension. The pensions are constructed so differently, vesting requirements are constructed so differently. But I always thought about a pension as something that kicked in after retirement, post-retirement. And this plan seems focused on something that's pre-retirement, activities pre-retirement, retaining employees pre-retirement. And yet the focus of a pension plan always seemed to me intuitively to be post-retirement. And that only applies, given that district court's finding of fact, to something like 8% of the employees. And that little percentage can't be utilized to just overturn the essential nature of the plan, can it?
Your Honor, let me answer your question by focusing on the text of the statute. And I think it's key to recognize that there are essentially three components to the 1002 definition of what's falling within ERISA. First is the welfare plan, which is not at issue, but it speaks to a purpose. It says, what is the purpose of the plan? Then you look at the provisions for a pension plan, and that's broken down into two components. One is, I think, what Your Honor is just describing, which is what we think of as a traditional pension plan, which is subparagraph 1, which says provides retirement income. And we don't claim that that's true here. But subparagraph 2, and there's the or between them, and so we know subparagraph 2 is its own test, says that you have a pension plan when you have a plan that results in a deferral of income. It doesn't say it has to result in a deferral of income to the end of covered employment. It says for periods extending to the end of covered employment. So it doesn't say it has to be conditioned on the end of covered employment at all. So I think it's very important to focus on the text. To answer, I think, the animating question of the concern that Your Honor has expressed is, do we have income here? Because to Your Honor's point, you have nothing to defer if you don't have income. And our position is you do, because you cannot collapse the question of whether you have earned something into the vesting requirement. Otherwise, you are essentially reading ERISA's vesting schedule out of the statute. So to look at whether this has been earned or not, we look at the way the plan functions, and this is key. The plan sets up compensation, the core compensation for these financial advisors tied entirely to the production credits under the plan. The quote-unquote base salary that Merrill Lynch points to is actually simply the guaranteed portion of the production credits. When you look at how these are calculated, you take the production credits, you multiply that by the grid rate, and then you back out any salary that essentially is guaranteed to comply with minimum wage rules. Out of that total compensation, this is how they get paid. Out of that total compensation, Merrill Lynch then says, we're going to take part of that, and we are not going to let you have it for another 8 years under the Wealth Choice Plan.
Well, but how can you defer something when you can't put your hand on it? I mean, we're talking about deferring in terms of some future expectation. I don't understand.
Well, may I answer your question, Judge Wilkinson? I think that what you're really getting at is there such a thing as a mandatory deferral? And I would suggest looking at the Tolbert case, because the answer is yes. The fact that Merrill Lynch has said, we are not going to give this to you yet, does not mean that they are not causing the employee to defer it by requiring that they do so under the terms of the plan. But I think the key is that this is all earned income, because it is a component, a portion of the income they have earned
they're not entitled to payment. They're not entitled to payment until the conditions of the award are met. And how, I keep coming back. I'm not sure how you find a deferral when somebody's not entitled to payment. To me, that's the key. One thing that you could help me out with. What are the other circuit courts doing here? It seemed to me that your opponents contend that the Second Circuit, the Third Circuit, the Eighth, and the Ninth agree with their position and would say that this is not that something structured this way is not a pension plan. So are we going to be creating a circuit split or on the small side of a circuit split? How do you deal with this is not a question of first impression with the circuit courts. A lot of them are dealing with similar situations.
Your Honor, I think the answer to that question is the only circuit court that has dealt with this situation is actually the Tolbert case. The other plans that are pointed to in other circuits, and I'm thinking of the Oatway case and the Emenegger case and the Rich case, are not really grappling with the precise contours of the plan at issue here. I'd also say the Tolbert case is the most, is really the best to look at, because the Fifth Circuit decided the Murphy case in the early 1980s, and Murphy is really sort of the seminal case in this space. Merrill Lynch tries to claim it as a case that supports its position. I do not think that is correct at all, because when you look at what that case did is, one, it made it clear that subparagraphs 1 and 2 are totally separate. And two, it evaluated the nature of the right in that case, which was a present royalty interest. And the fact that payments on the royalty interest didn't happen later meant there was no deferral, because you already had the royalty interest. It was just a question as to when things were going to pay.
Jasinski, there is this question here, whether this is deferral income, but you've got less than 2 minutes, and there's an aspect of this case that if we look at that Department of Labor regulation, there is a bonus payment plan exception here. And it appears to me that at least this instance seems to fit under the very definition of that CFR regulation that the Department of Labor set forth for bonus payment type exception. How do you address that?
Well, I would address it by saying we don't think that this is a bonus. And I would note that it's pretty curious that the Department of Labor purported to clarify the statute by using the term bonus without any definition. The contingency here is staying. And so to answer both of your questions, Judge Wynn and Judge Wilkinson, I think that the challenge that you're having is saying, well, you haven't gotten this payment unless you've stuck around for the 8-year period.
But you don't have a problem with us looking at that regulation on the LOPR or
No.
any other type of.
Your Honor, I would submit that the regulation contradicts the text, and we briefed that in the papers. But I don't think you have to wrestle with that, because I don't think that this is that these are bonus awards. They are compensation that is tied directly to the same compensation they pay on a monthly basis. It's just they carve out a portion of it and they say you can't have it for 8 years. The contingency that they say is the bonus, congratulations, is sticking around for 8 years. The very thing that ERISA does is say that a company can't bind somebody to them by telling them they're not going to get their income unless they stay. And that's exactly what the vesting schedule in ERISA is designed to protect. So I see I have 8 seconds. I'd be happy to address any further questions, or obviously I've reserved 5 minutes for rebuttal.
Wilson, I have a question. May I proceed? Counsel, my question is about the second part of subsection 2. So you've spoken quite a bit about the deferral of income section, but then it actually continues to say for periods extending to the termination of covered employment or beyond. So here we have a program where, as Judge Wilkinson points out, for the majority of employees, vesting occurs at 8 years, but there are employees where vesting occurs earlier, where the assets become available to them earlier because of retirement or, I suppose, some RIF, is my understanding. If those provisions were not included in the plan, in other words, if everyone had to wait the 8 years, would it still be your position that subsection 2 applies?
I would grant you that that's a harder case. I could argue that it does, because the nature of this plan is that the awards are granted annually, but the deferral period is 8 years, which means an employee will never catch up. So the way that this plan is oriented, it is literally designed to leave money on the table for the entire career that somebody is at Merrill Lynch. So they will always have some portion of deferred compensation, and that'll be true right up until the point that they leave. But I think this plan, by design, is an even stronger case for ERISA coverage, because it does explicitly provide that there are certain points at which the plan will pay awards upon termination, or in the case of retirement, it actually extends the deferral by essentially 2 years, paying 50% within the first year after retirement and the other 50% within the second year after retirement. So what's interesting is Merrill Lynch's point here is essentially to use the deferral of income to require employees to stay with Merrill Lynch for their career or penalize them if they don't. And to me, that is exactly what ERISA is designed to prevent.
What's wrong with trying to encourage an employee to stay? We have all kinds of ways of encouraging employees to stay. The company is, I don't see anything in this law that prohibits a company from adopting programs that are designed to encourage loyalty and continuity of service on the part of employees. It's not that they're not up to anything illicit. Companies are trying all the time to encourage loyalty and stability in the workforce. But anyway, you've got some rebuttal time that you've reserved. I'm going to ask my friend Judge Berner if she had additional questions of you, in which case we'll wait until you answer those.
This question is following on Judge Wilkinson's point. Isn't it true that your argument is not that this plan is prohibited, it's simply that it's ERISA covered, and so it would need to comply with ERISA? In other words, ERISA would permit the plan to go forward. It would simply need to comply with the constraints that ERISA puts on plans.
That is correct, Your Honor. Yes. And I don't think there's any dispute that this plan, in terms of the cancellation provision at issue, would violate ERISA if ERISA applies, which is why we're here.
In other words, you're not arguing it's unlawful. You're simply arguing that it needs to comply with ERISA, or it's covered by ERISA.
That is correct, Your Honor, with respect to the plan as a whole.
Well, that's the whole question, is whether this is covered by ERISA or whether it's not. But it makes all the difference in the world as to whether it's covered in terms of massive regulation and all that follows. So we have we can agree on what the question is. We just everybody in the room may just not be able to agree on the answer.
I'm sensitive that I'm over time, Your Honor. I do hope to have an opportunity for rebuttal.
Wait until your rebuttal time, and then you can tell us why you think the opposing counsel is wrong. And Mr. Kennelly, is it? We'd be happy to hear from you when you're ready.
Thank you very much, Your Honor. My name is Michael Keneally, and I represent Merrill Lynch and Bank of America. May it please the court. Like many names, Merrill Lynch designed part of its compensation process to incentivize high performance and longevity at the firm. The company offers retention bonuses to financial advisors who surpass a certain productivity threshold for a given year and remain at the firm for 8 more years.
But the fact that something has a laudable purpose and everything, and I do agree with you that this has a laudable purpose, but the question, I think, revolves around this 2 particular phrases. One is the question of what do we mean by a deferral of income, and the other is what do we mean by extending to the termination of employment. Those are the 2 critical textual questions. And in addition, I think Judge Wynn makes a very good point about whether this is a bonus or has the characteristics of a bonus. I realize that that was an alternative argument, but it still seems to me something worth considering. So I don't think whether it's a good program or a bad program is critical. I think that the question is it a deferral? Does it extend to the termination of employment or beyond? It's those, we just need to bear down on those textual words.
I'm happy to do that, Your Honor. So let me start with deferral of income. Because as you noted, this is not a question that's really of first impression amongst the circuits. Other courts have wrestled with what this language means. And I would point to the Fifth Circuit that my friend was discussing, including Tolbert and the case that relied on Boos, which describe a deferral of income as arising when employees forego income when it is earned in exchange for receiving that income later. And the Tolbert case that Mr. Jasinski relies heavily on is very different from the facts of this case in an important respect. The express terms of the plan in that case referred to the plan as a deferred compensation plan and explained that by design, employees had the option to defer receipt of a portion of their compensation to be earned with respect to the upcoming plan year. They could defer that income until they leave employment. And so in that case, you really had a deferral, an option for the deferral of income by employees. And I don't think we want to lose track of those 2 words because they're right there in section, a deferral of income by employees, plural. That suggests that the employees are deferring income, as often happens. And in Merrill Lynch in particular, there is actually a voluntary deferred compensation plan that is governed by ERISA, that is wholly separate from the Wealth Choice program, just as there's a 401k program that's governed by ERISA, wholly separate from the Wealth Choice program. And so you do have voluntary compensation plans like the one in Tolbert and the one in Wilson versus Safelight, where the employees have the option of keeping their money in an account. They're not earning it, they're not paying income tax on it at the moment. They're going to defer receipt and recognition of income until later on, often for tax advantages. But that's not anything like what we have here. Here, as was discussed in the first bit of argument, there is no right to receive the income unless the conditions for 8 years are satisfied.
In order to be covered by ERISA, as I understand it, the appellants would have to prevail both on the deferral point and on the termination of, extending to the termination point. If either of those points is, if they don't prevail on either of those points, then it would not be a covered plan, as I understand it. Is that correct?
That's correct, Your Honor. And this court has actually addressed the deferral of income language in the Fravor versus North Carolina Farm Bureau case. And I think that its conclusion there is inconsistent with Mr. Jasinski's argument today. Their insurance agents received post-termination payments, so after retired, that were on a 5-year graded vesting schedule. And they were calculated based on the sales commissions that those agents generated during their final year of work. And court squarely held that those payment provisions did not establish a deferral of the agent's income to the termination of covered employment or beyond. And if plaintiffs' understanding of this...
But that case wasn't a case where the individual employees were earning the deferred income each year and it was calculated each year. That was based on the final year of employment. So it's factually quite distinguishable. I actually want to take you back to the Sixth Circuit case, which is, I think, the closest case on point, and also post-Loper-Bright, in reference to this issue of the application of the DOL regulation. So my understanding is in Tolbert, the plan actually did have a component that is, as you described, where employees chose to defer a portion of their compensation post-retirement for tax purposes or tax benefit. But there was a portion in Tolbert also, like here, as I understand it, that where the employees had essentially no choice, where a portion of their income was deferred, and for that reason, the court found that it was covered by ERISA. Were those not the facts in that case?
Not quite, Your Honor. So in Tolbert, all of the 3 components of the plan, the wealth accumulation, and company contributions, all 3 of those components could be deferred at the option of employees to the termination of covered employment, to their separation from employment. And in this case, there's no ability to defer anything once the Wealth Choice Award is vested. It has to be paid out within 30 days. And that's in the record. There's no ability to keep the money in the Wealth Choice plan and then receive the income afterward. And the Wilson...
Unless an individual retires.
Unless an individual retires, then the company will pay out the wealth choice. But that's not an option that anybody can invoke. I think the strange thing to me about Mr. Jasinski's position, and I think he admitted that if Merrill Lynch eliminated the payment to retired employees and just said, we're not going to do that anymore because it's going to trigger ERISA, that would be a harder case for him. And it would be very strange to me for the Employer Retirement Income Security Act to give employers a serious incentive not to make payments to retirees in order to avoid triggering all the statute's requirements. And
let me understand where you're going with that, because example you give an employee who plans to retire in more than 3 years, but less than 8, but he allocates a portion of their long-term contingent award into this wealth choice program rather than the restricted stocks unit. That sounds like it's deferring income until after retirement.
So I don't think so, Your Honor. So all of the awards under wealth choice will be either allocated under restricted stock units or wealth choice awards. That's
understand
true.
it, but my question goes to this instance that you created here of an individual who can retire after more than 3 years, but less than 8. And then, but they've allocated a portion of their long-term contingent award into this wealth choice program, not under the restricted stock unit, which is an alternative, I understand. And I'm saying that sounds like a deferment of income until after retirement.
No, Your Honor, because the employee won't have any right to the income until at least retirement, or if they don't retire. And so they can't get the money now. There's no deferral of income when the income isn't available to the employee, and that's different.
Well, I'm not. I think we're sort of parsing words, but at least the beginning of it is that you got someone who does this from the inception. They plan to retire, and they set this thing up so they're going to retire with more than 3, but less than 8, and they retire, and then they're going to get the money. That's deferring income for that particular person. I mean, at least for that individual, is it not?
I don't think so, Your Honor, because then retirement is the earliest they could possibly get the income. I mean, the default vesting requirement would be 8 years. So it sounds like they're accelerating income under your hypothetical because they're getting it before 8 years because they choose to retire earlier. But there's no ability to get the income before retirement.
Well, I only brought it out, and I mean, this is really convoluted, but it seems like to me the restricted stock unit would pay out earlier. And if you choose to take this instead and said, I'll take this, he has deferred that which he could get through the restricted stock unit earlier and until this actually kicks in after 3 years, but less than 8.
I see what Your Honor is saying, but even the restricted stock unit has a vesting period, and under Mr. Jasinski's view of the statute, there's nothing magical about 8 years versus 1 year or 3 years, and in either of those cases, there will be a gap between the the performance of the services and the payment that results from them. I also don't want to lose track of the bonus regulation question because that did come up from a couple of members of the court. We do think that the bonus regulation is an independent ground.
Well, I do want you to focus on that because I'm looking at that regulation and, I think it bears some discussion. I know it's an alternative argument. If everybody accepts that, that regulation is good, and that exception is good, we don't get into this whole business of, can the department do it, or do we have jurisdiction, that sort of thing on the LOPR. If we beyond that, then when we're looking squarely at those those provisions there, it looks to me as though this could very neatly fit within what the Department of Labor has characterized as a bonus plan exception.
Yes, so I'll take those 2 points in reverse order. I think this is a bonus program, just as one usually uses the term bonus. The Eighth Circuit defined a classic bonus situation as a reward for superior performance. And the Sixth Circuit in the Wilson case said that a bonus plan typically states that the purpose is to pay an additional incentive to encourage performance or retention. And that's exactly what the Wealth Choice Plan says on the very first paragraph, page 67 of the Joint Appendix. So I think that there's clearly a bonus program here. Mr. Jasinski has argued in the briefing that commission-based payments can't qualify as a bonus program. I don't think that that could be true for 2 reasons. One, the statutory language, this is section 1002(2)A, specifies that the pension plan definition applies regardless of the method of calculating the benefits. And his argument on commission seems to be that calculating the benefits in terms of commissions means that we have a pension plan, but that should not be a relevant consideration of the statutory definition. And even the 10th Circuit decision in McKinsey found a bonus program where the amount of sales credits produced by employees were what determined the amount of the bonus. And so that's very much like what we have here. So I think that this is a bonus program. And then to get back to the first point that Your Honor raised about Loper Bright, and I think this was Judge Berner's question as well, I think it's important to underscore 2 points about Loper. First, the Supreme Court said that when Congress delegates authority to an administrative agency for the details in a statutory scheme or to define particular terms, that is an important part of what the statutory meaning is, and courts should give that congressional delegation effect if it's consistent with the Constitution's non-delegation.
Well, even after Loper, I'm having trouble hearing you, Mr. Kennelly. Even after Loper Bright, we're still entitled to consider the persuasiveness of a regulation in terms of the statutory delegation. So you still have Skidmore deference, which could be important here, particularly when the regulation is promulgated by the department with primary responsibility for these matters. One thing I was thinking we focus in on deferral and to the termination of employment. It's possible, I suppose, to take a global look at this. Intuitively, I've always thought of a pension as something that kicks in post-retirement, regardless of how it's structured. You can have interest vesting in different ways and at different times. But I've always thought of a pension as something that kicks in post-retirement. And here the focus of the program is pre-retirement. Is that correct in your judgment?
Yes, Your Honor, and I think that's how other circuits, to question Mr. Jasinski, have looked at this. They have looked at how the program is designed and what its purpose is, and whether the payment to retirees.
All I'm saying is that, just from a rudimentary first grade perspective, a pension is something that you look forward to in your retirement years. That's what you work for. That's what you save for. That's what your whole planning, your family planning is for retirement or something that kicks in your retirement years. Now, the whole thing about this, the whole focus of this and the program, for the vast majority of people, this kicks in pre-retirement because the 8-year period is likely to expire pre-retirement. That's not true in every case. But the thing about it is I wonder whether we just sort of run headlong into what we all know are pension plans. Now, there are something, I think there was a finding that 92% of the employees got their bonus or their award pre-retirement, that there was something like 8% that did not. Now, does this force us into some kind of line drawing exercise? I mean, down the road, suppose we had 20% of the employees that received their award post-retirement, or 15% or 25%. Are we in the middle of a line drawing exercise, and how do we deal that? Do we just pick a number out of the air and say, this is de minimis? So what do we do about the percentage of people that receive the awards pre-retirement vis-a-vis the percentage and number of people that receive the awards post-retirement? Well, how do we deal with that? Because I don't want to be a legislator.
Yes, I think that's a fair concern, Your Honor. I think the bonus program regulation uses the phrase systematic deferral. I don't know how much more helpful that is, but the case law has often referred to whether retirement payments are incidental to the regular purpose of the program. I think
you're really asking us to look at the purpose and not at the statutory language. And as I read your purpose-driven interpretation, it really collapses subsections 1 and subsections 2, where everything becomes a pension, and it eliminates subsection 2. And subsection 2 begins with the words results in, and we know from the Supreme Court that there's a definition of results in, which is something that arises as an effect, issue, or outcome from some action, process, or design. And that's the Burrage opinion. And so, to my mind, it seems that if it results in it, even if it's 8%, then that's the statutory language. And a regulation can't alter the statutory language. That even if we provide Skidmore deference to this regulation, we can't alter the statutory language.
Well, Your Honor, every court of appeals that has addressed this question has said that merely providing incidental payments to retirees is not, or to dead or disabled employees, is not enough to turn a program into a pension plan. And that would be a really radical conclusion to draw, because it would give employers a very strong incentive to just not make those payments at all.
So you're saying eight, sorry, Judge Wilkinson.
You go ahead, Judge Berner.
You're saying then 8% is incidental? And as I understand it, it's
yes, I think 8%.
And it's 15% if you look to the dollar amount.
No, it's not if you look to the dollar amount. If you look cumulatively over the course of 6 years, it gets higher, unsurprisingly, because more employees retire over a longer period of time. But our statistics were every single year, it's 91% to 94% active employees who receive the wealth choice payments. And I think that's the right way to look at the numbers, because we're looking at an annual award and we want to know how it operates in practice. We're not saying you look to purpose to the exclusion of operation in practice.
Well, but we don't want to be backed into the situation. On the other hand, whereas if you have one single employee who happens to receive the award post-retirement, that somehow the entire plan is invalidated and toppled. I mean, there is a practical question here, and that is, you can have a line drawing exercise if you affirm here, but on the other hand, if we reverse and say this is ERISA coverage, we're getting into the situation of where a single employee receiving a post-retirement benefit brings the whole plan within ERISA. And that, the consequences of that would be devastating. But the other question that I have here is, I always feel like it's not a good thing for a court to kick up dust. And we have a situation where companies have relied upon this plan. They had no reason, I think, no serious reason to think that what they were doing was unlawful or running afoul of ERISA. The financial advisors knew what the ground rules were. The companies knew what the ground rules were. They've been operating under these plans for a number of years. And if it strikes me that we are just going into this and we're going to overturn these long expectations, and we're just going to be kicking up a lot of dust, and it's going to result in immense practical consequences. It's not just a slew of regulations. In fact, it's a lot of penalties, which may or may not be retroactive. The consequences of overturning settled expectations and making a decision like this results in kicking up dust, lots of dust, both in the sense of an immense regulatory burden, but also in the sense of penalties, all of which will have to be litigated out. I mean, it's just impossible to overestimate the consequences of holding this particular program on whatever, of invalidating this particular program. It just is, it's not just kicking up dust, it's kicking up a sandstorm. There's a practical dimension to this whole thing.
That's correct, Your Honor, and it raises a good point that there are also tax implications. If employees are receiving retirement plan disbursements before retirement age, that could create penalties under the tax laws as well. So there would be a lot of downstream consequences, and no one in the industry, as the amici point out, would be prepared for that if the court were to reverse.
All right, Judge Wynn, do you have further questions of this gentleman?
I do not.
Judge Berner? And you have some rebuttal time, Mr. Jasinski, and so we'd be happy to hear from you with that rebuttal.
Thank you, Judge Wilkinson. Just to, if I may respond to the concerns that Your Honor, Judge Wilkinson, raised with respect to kicking up dust. I don't actually agree with that. I think, you know, I would urge the court not to be.
Let me just say, I'm shocked and surprised that you don't agree with me.
Well, let me just put it this way, if I may, which is I would urge the court not to be a fair weather textualist. I think that what matters here is the text of the statute. I think that the Tolbert court in footnote 6 made that very clear where they addressed similar.
When you talk about a fair weather textualist, you know, my memory serves me appropriately. It seems to me we've been spending much of the past hour talking precisely about the text and the meaning of the word. We bored down heavily on.
Well, let us return to that then. I simply offer that, as I think the Tolbert court remarked, the parade of horribles that amici may raise do not tell us what the language in subsection 2 means. And I think that we do need to anchor ourselves in that. And I think that Judge Berner had asked some questions that really teased out the point that when we consider what I think Your Honor, Judge Wilkinson pointed to as the sort of common understanding of a pension, that is covered in subparagraph 1, which is the retirement income provision. Congress did not say anything in subparagraph 2 about requiring that retirement be a component of a deferral. It says to the end of covered employment or beyond. Somebody, of course, may leave covered employment at any point in their career well short of retirement.
Well, when you say extending to the termination, doesn't that key off retirement to an extent?
No, I disagree, Your Honor, not at all, because of course the end of covered employment could be well short of retirement age. And to that point, I mean, I think what's key here is, let me speak to the bonus regulation. I want to make clear, and I don't want to spend, I've got only a little bit of time. We do not believe that this regulation is valid. There's no way that the DOL can create an exemption from a statute that Congress enacted. But be that as it may, we also don't think that this is a bonus in any sense of the word. And let me give you the example why. What is the superior performance here? Not dying? That to say that they're superior performance because they have stuck around long enough to get that portion of their commissions that were deferred into the future is to totally upend the notion of what a bonus is. There are other components of compensation offered by Merrill Lynch that we do not contest in this case. They're not at issue here, but I think would be a stronger case for a bonus argument. For example, service awards that are included in the plan. But here we are simply taking, or Merrill Lynch is taking a portion of the annual compensation calculated annually and saying you will not receive this part of it until the future. Judge Wynn, I thought you really touched on something important with your question concerning the difference between an election of the restricted stock units and an election of the Wealth Choice Award by an employee who intends to retire after 3 years but before 8. And the reason I think that is such a key point to make is it reveals the fact that the money is already earned at the time that the end of that performance year is done. Because it makes no sense that then an employee who would be entitled to receive that money after 3 years is not entitled to it between 3 and 8 years if he has made the election to put it into this other plan. And by way of further example that this money is earned in the performance year is the fact that, and you can look as an example at page JA858 of the appendix, if the calculation of the portion of the commission that is deferred results in a number that is $1,000 or less, or perhaps it's less than $1,000, that money is paid immediately. So the notion that this is not earned yet is belied by the fact that when Merrill Lynch doesn't want to bother to deal with taking less than $1,000 and putting it in the Wealth Choice Plan, it simply pays the money. So
wouldn't you say though, if we go in your direction, that at least the interpretation you give the statute it certainly would throw out the very purpose that this plan was created for. But do you maintain the purpose of the plan is just irrelevant when we are construing this statute?
I absolutely maintain that, Your Honor. There is no purpose requirement at all built into this provision. And you can tell that because when Congress cares about the purpose, it says so. It uses the word in the definition of a welfare plan. So there is no purpose. This is a results, a consequences test only. It does not matter what the purpose is. But having said that, I think it is key that the stated purpose is to keep these folks there for their entire careers. And that is exactly what ERISA is intended to prevent.
Mr. Jasinski, I want to point to the language that your friend on the other side pointed out, which wasn't really addressed in the briefing, the by employees language in subsection 2. As I understand it, this plan doesn't allow for that all of the deferral is done by the company. In other words, there's no choice here for the employees not to defer this part of their income. And so I am concerned that subsection 2 would not apply because the deferral is not done by the employees.
I have a two-part answer to that question, Your Honor. The first is I think it's important to look at sort of higher up in the text where it says the plan results in a deferral by employees. So the actor here is the plan. The plan is what is causing something to happen, and it is causing a deferral by employees. I think the Tolbert case made it very clear that the fact that a deferral may be mandated doesn't change this. And obviously, I think Mr. Keneally and I read Tolbert differently. But when you look at that case very closely, the court drew no distinction between any kind of voluntary component of deferred compensation and the mandatory component. And in fact, the only dispute was over the mandatory component because under that plan, the voluntary component was fully vested. So the reason they were before the court was because there was a cancellation with respect to the mandatory portion of the awards. And the court said that even though it's mandatory, that the employer requires it, that still constitutes an employee foregoing compensation today for compensation in the future.
Do we have any further questions? Judge Wynn, do you have any further?
I do not.
Judge Berner, do you have some further questions? Pardon me?
No, thank you.
Okay, I have no further questions. I want to thank both of our lawyers for their able arguments. I wish we were doing this in person because then we would hop down from the bench and come by and shake your hands. But the fact that we're operating remotely in no way diminishes our appreciation for the quality of your advocacy. So thank you both very, very much and have a nice day.
Thank you, Your Honor.
All right, we'll go to the case immediately.
Good morning, and may it please the court, Ariel Rosenbaum for appellate Mr. Warner Guevara Martinez. This case is about an agency failing to fulfill its responsibility to Mr. Guevara Martinez to assess his claims, in particular, his arguments related to the PSC standard, and provide a reasoned opinion explaining the agency's analysis. Mr. Guevara Martinez has three main claims. First, the agency did not conduct the proper analysis under the two-step framework and thus erred in finding Mr. Guevara Martinez's misdemeanor conviction to be a PSC. The government tries to salvage this error by advancing the unprecedented argument that step one of the PSC analysis is immune from judicial review, but this court must reject the government's baseless theory. Second, the agency's findings of inconsistency were improperly based on insignificant variations in dates and wording. And third, the agency erred by failing to consider the full panoply of risk of torture evidence in its CAT analysis, particularly the fully credited testimony of expert Professor Fontes. To return to the first argument, the government's novel argument that step one of the two-step analysis for determining whether a crime is a PSC is immune from judicial review is unsupported by the established precedent of the Fourth Circuit and its sister circuits. Interpreting the PSC statute, and specifically analyzing the elements of a crime at step one, is directly within the court's purview. The agency should not be given deference for this purely legal analysis, let alone be wholly insulated from appellate review. The government's interpretation was not directly raised or decided in Anor v. Garland, but that decision and the decision of other circuits demonstrate why the government's approach is meritless. In Anor, this court had no trouble reviewing the agency's step one analysis and identifying errors in that analysis, finding that the agency considered the elements of the wrong statute altogether. Moreover, in both Luziga and Ojo, the courts vacated and remanded BIA decisions in cases where the agency failed to properly evaluate the elements of the offense at the first step of the NAM inquiry. In fact, in Inor, this court explained that an agency has committed legal error if it merely observed that the offense at issue was a crime against persons without considering its elements at all. And the BIA affirmed.
You have these asylum cases in particular hinge on credibility findings, and didn't the IJ, who's a trier of fact here, make the finding that the petitioner was not credible?
The IJ did, but both asylum and withholding of removal claims can be supported by objective evidence, and the petitioner wasn't able.
I know, but the key in these questions, whenever these questions are debated, I've seen so often applicants for asylum say, well, the IJ made a finding that my witness was credible. Well, doesn't the obverse apply, that if there's a finding that the petitioner was not credible, that may not by itself be dispositive, but it sure works to your disadvantage.
We do still find legal error was committed by the agency, and that legal error resulted in injustice. So specifically, at step one, the agency failed to adequately explain why a misdemeanor conviction for assault and battery against a family or household member under Virginia law falls within the ambit of a PSC. The IJ's analysis was inadequate in precisely the way that this court recently articulated in Orr. After stating that statutory assault and battery incorporates the common law crime, which is willful or unlawful touching of the person or another.
You're trying to get away from some of the acts that are adverse to your position. You had before the IJ, Mr. Guevara portrayed himself as a victim of misunderstanding, who was trying to protect his partner from harm. And honestly, he was doing quite the opposite. He was not trying to protect his partner from harm. He was visiting harm upon his partner to an egregious extent. And the evidence indicated that in some of this, the police observed that this individual twice assaulted his girlfriend. He did that in violation of a protective order. He stole her cell phone twice. He assaulted his niece. Gripped his girlfriend's hair and violently threw her to the ground. When she tried to call the police, he ripped the phone out of her hand and kept it. The officers who witnessed some of the abusive conduct first half, there were bruises on his girlfriend's arm in the shape of fingerprints. And the idea that he was trying to protect his partner and her niece is exactly the opposite of what happened. And whether you go at this by the fact that the asylum claim has not been out, or whether you say this is a particularly serious crime or not, it would seem to me that the ultimate question is, did Congress wish someone who is guilty of gross domestic abuse to remain in this country?
Well, Your Honor, a couple of thoughts. The first being that these facts and circumstances surrounding the particular crime committed, that's properly considered at step two, not at step one, which is where we're saying legal error was committed in not considering whether the elements of the offense bring it within the ambit of a PSC, which the IJ here simply did not do. All he said was that the crime was a crime against persons, and thus it was within the ambit of a PSC, which again is exactly what this court found in Inor to be lacking as a step one analysis. But yes.
What, is it a problem for the agency just to swap the order of the steps?
Yes, it is a problem, in fact. As this court found, it's 2 steps for a reason, and the first step comes first. You must first consider the elements of the crime to see whether it is even raised to the level of a particularly serious crime. And that goes to Judge Wilkinson's point, as well as the question you just raised. It's not any crime we're looking at. There's no question that here there was a violation of law, but the threshold here is very high. It's a particularly serious crime, not just a grave crime, not just a crime, but a particularly serious crime such that it can prohibit someone with a well-founded fear of persecution from being granted asylum or withholding of removal. So it is in fact incredibly important that we apply the correct legal standard, which is
But if the outcome is predetermined and these facts are simply horrific, and I don't think here this is asylum is a case-by-case determination, and it depends upon facts. And I think it's a different kind of situation from the normal criminal process, where in sentencing you adopt a categorical approach to predicate offenses. I don't understand the asylum process to work in terms of a categorical approach. There's a certain practicality to it, and it's very fact specific. And the facts here are just horrible. You say, well, this is just this category of misdemeanor, but if the facts are horrible and the ultimate determination is really not in doubt, and I can see from this record that a remand would do nothing more than reaffirm the result that we have here. It can't be reversible error that someone decides to go to what the evidence indicates is the appropriate result in the case. We'd be insisting on a formalism at the expense of what the facts show happened. And what happened was it was abusive, it was predatory. It is exactly the way that we do not wish men to treat women. It was in violation of a protective order. It just you read on, and it just gets worse and worse.
Well, Judge Wilkinson, 2 points to address. First of all, in Inor, this court did find that the formalism, whether we're looking at function formalism, that doesn't prohibit this court from finding legal error needs to be remedied, and legal error is an injustice that does deserve, in that case, it was vacated and remanded. And the other thing I just want to mention very briefly is the violation of the protective order is actually a separate misdemeanor that was not considered by the IJ in
the Anor case is probably your strongest point on this, and I think your point is Judge Wilkinson's right. When we do it, when we go through it, where we could come with all these facts. The problem, at least from what I see, is this IJ just said that this offense falls within the ambit of a particular serious crime, and he gave no explanation. He didn't analyze it under that statute. He didn't say any of that stuff Judge Wilkinson just said, which I agree, the record shows it, but that's not our review. And when we look at Anor, it looks like the same case to me, that essentially that's what happened. But now, what Judge Wilkinson said may well be true, though. Send this back, and it sounds like to me, IJ just basically parrot just what was said here, and it's going to end up the same place. Because the question is that for us to make a decision as to what would happen if it goes back in light of Hanoi? Because Hanoi seems to be very clear that this is something that IJ, now I will say, I looked at this record, and you sometimes don't know the tenor of how things are done, but that was a rather brusque IJ you had there. I mean, he was very, and the credibility finding is another instance, and I'm not sure I don't agree with where Judge Wilkins is going with that. I think that's a difficult road for you to travel there because of our review limitations, but nonetheless, it does not prevent a remand on this or the cat claim, denial, if there are errors there. So, at least from my perspective, and particularly in this one, with what I see as an annoy, and I'll ask you a colleague of that too, because I think that's, to me, at least on this issue, that's a key case. And then we don't have to get to step two if step one wasn't followed. Looks like to me, and to answer what I think is Judge Berner's concern of whether or not you can skip one to the other, just like you do in the Section 1983 type case. I don't think so. I think you've got to do step one, then go step two, because you got to first analyze the elements of the statute, and that was not done. He just said it's a particular serious crime. Now, I couldn't disagree. I couldn't disagree if I was saying if the standard review was common sense and what it looks like. But no requires you to go through those elements and come to that conclusion. So I think that seems to be the point you're making. But how much am I off on that?
I completely agree with Your Honor. And I also think that what you said about speculation is important too. We could guess where the outcome might be if it was remanded, but we in fact don't know what the outcome would be. We don't know how the PSC analysis impacted the BIA's review. So it is important that this is remanded, not only so that the legal error at step one is considered, but also
this whole kind of step one, step two, but the ultimate question here is not step one, step two. It's whether the findings that were made, whether there's substantial evidence that supports those findings. And the question, that's what we have to look at according to all of our precedents, and that is, does substantial evidence support what the ALJ or what the IJ and BIA did in their denial of the petition for asylum, withholding of removal, and CAT? Either substantial evidence supports it or it doesn't, but that's the standard of review.
So, Judge Wilkinson, I note that I have 13 seconds, but if the court would please allow me to just answer this one question. Respectfully, we find that the standard of review for this step one analysis is not substantial evidence. It's de novo because this is a legal question. And in Honor, this court favorably and extensively cited Ojo v. Garland, a decision from a sister circuit, which did explicitly find that this question is reviewed de novo. So we do not believe that this question is one of substantial evidence. And I do see I'm out of the time. I did reserve 5 minutes for rebuttal.
Ms. Rosenbaum, you can save the answer to this question for your rebuttal time, but my question is, if we were to find that there was legal error, is there a harmlessness step review here? Because I think what Judge Wilkinson is saying is there's sort of no point in remanding because the outcome would be the same. And so I understand that this issue wasn't briefed by either party, but I do wonder whether a finding that any error is harmless would be appropriate in this instance.
I'm happy to address that on rebuttal if that's how the court would prefer. Or
I think that's preferable. It also gives an opportunity to Mr. Lorenz to answer the same question.
Thank you so much.
Mr. Lorenz, we'd be pleased to hear from you, sir.
May it please the court. My name is Jesse Lorenz, and I represent the Attorney General of the United States. Mr. Guevara is ineligible for asylum and withholding of removal for two reasons, two independently dispositive reasons. First of all, he's not eligible for asylum and withholding of removal because he did not present a credible claim. That alone is dispositive of those applications, regardless of how this court feels about the particular serious crime determination. And I'd like to start by talking about the credibility determination, which is supported by several specific and cogent reasons for disbelieving his claim. He presented several inherently implausible claims. First of all, he talked about hearts being attached to a pacemaker in a cooler that were being shipped from Guatemala to Arizona. That's inherently implausible. He also said that his kidnappers released him after beating him for 2
It's
or
not
3 days.
inherently implausible, it's a joke.
Well, I think the claim is inherently outlandish. I mean, he also claimed that he was shot in March of 2013, but somehow didn't seek medical attention until October of 2013. Even setting aside those really inherently implausible things, his testimony about his conduct that led to his 2013.
Mr. Lawrence, if we accept that, in fact, the adverse this decision, at least in terms of credibility, is correct by the IJ, okay, he's not. Is there not still the legal question of whether this is a particularly serious crime, for which I think Ms. Roosevelt may have correctly stated the review is de novo for a legal question of whether this is a particularly serious crime, and you would have to analyze it under the Virginia statute here to determine that. So, I mean, we can spend time dealing with the credibility, and you are right. As Judge Wilkerson pointed out, there are some absurdities. I mean, finding a heart in a cooler that says it's transplant, I mean, it challenges that. But that still leaves us the determination of the legal question of whether this is a particularly serious crime. And the IJ, and I'll go directly to the point, because much of what's being said here is what's in the record. If it's a substantial evidence, oh yeah, we can comb through it and find it. But if it's a noise seems to make it very clear, this is a legal question. And this IJ was very blunt about it. He just said, oh, it's a particular serious crime, and didn't give anything else. Isn't more required for step one?
Well, I'd like to start up by noting that the adverse credibility determination is entirely dispositive of asylum and withholding of removal. So this court wouldn't even have to reach the issue of particular serious crime to deny the petition for review. But secondly, this court has traditionally reviewed the particular serious crime determination for an abuse of discretion. At the step one, we're talking about a crime potentially falling within the ambit, suggesting that it falls within the ambit. It's a threshold screening determination, and it's basically just finding whether the crime potentially could fall within, and then you would engage in the step two determination. I would suggest that this crime definitely potentially falls within the particular seriousness definition, and then looking at step two, I think the facts clearly show.
But doesn't Hanoi require more than you just would find that potentially it would be, where the IJ has done nothing of the sort?
Well, I would disagree with that, Your Honor, and I think the language even in Honor is pretty clear that we're talking about a crime does not, it just has to suggest, I mean, this is a quote from Honor, suggest the crime may be particularly serious. That's step one. And I think, you know, a victim being a domestic partner, a crime against a person, that would suggest very strongly that a crime could fall within the ambit, potentially could fall within the ambit of particular seriousness. And then moving on to step two, again, I think the evidence is overwhelming that this crime did constitute a particular serious crime. I mean, we have his testimony. I mean, he doesn't even acknowledge that he did anything wrong here.
Is our review of step one de novo, or is our review of step one a substantial evidence of for the findings?
Well, first of all, the government would argue that there is no discernible, meaningful standard. So under Heckler and under U.S. Bank and under Wilkinson, this court shouldn't even review that. But otherwise, we argue strongly that it is.
Is there anybody that agrees with you on that point?
No. Well, this is a novel argument that we've raised.
Yeah, that's new. No one's come up and said that. So let's assume for my question, we got to review it. My question is, if we do review it, is it a de novo review, or is it one that requires a substantial evidence type review?
Well, like I said, traditionally this court has reviewed the particularly serious crime determination for an abuse of discretion. Now, a legal question is reviewed de novo, and I want to defend quickly the jurisdictional argument we're making. I mean, I think over the years the Supreme Court has definitely defined and re-examined their jurisdiction. And I think it is important in these cases where this really is an unfettered discretionary determination of whether something falls within the wide ambit, the wide net of particular seriousness, that it is important to maybe re-examine these things to see if there is any standard by which to judge this. And I really suggest strongly that there's not. And I think the point that
your point is well taken. I think you're right. I think the Supreme Court has made some moves to do this, but we're very circumspect in terms of what the Supreme Court tells you. I think it has to be very specific. And on this particular point, to determine whether a crime is a particularly serious crime, it seems elementary to me that you would look at the elements of the statute. I mean, it's not and then you would look at it. There are certain things you would look at more than what this IJ did. And I will agree. You go back, and it may well be that at the end of the day, it's going to happen the same thing. But at least you ought to make a colorable attempt to do it, other than just say this is a particular serious crime and then nothing else.
Well,
which is pretty much all you got from the IJ.
But we don't require this. Isn't a categorical approach or a modified categorical approach. This is a matter of NAM is very clear, and this court is clear that this is something
that's what's going on.
Potentially.
Excuse me, counsel. This is what's going on here. All of these questions should be reviewed under a substantial evidence question, and now the attempt is being made to transfer the categorical approach, which is we obviously use in determining predicate crimes in repeat offender situations, Armed Career Criminal Act, and et cetera. But it seems to me when you switch over to the immigration context, that's much more evidence-based, and you can look at facts. You don't have to ignore them. We don't have to say certain offenses are particularly this, certain offenses are particularly that. You can't get away from the facts in this case. You just can't get away from them. And the substantial evidence standard, which is a universal standard applied by the courts of appeals, draws us into the facts. And when you're drawn into the facts, you have someone with a fantastical, ridiculous story about pacemakers and skulls and everything else. I mean, it was absurd. And you have an adverse credibility finding. You have a fantastical story that would pass no one's discerning review. And you have facts that, as far as I can see, are not seriously disputed, that just go on without end in indicating how are we going to say, oh, well, this kind of abuse of a woman is not a particularly serious matter. It's a heck of a particularly serious matter.
Well, I agree, Your Honor. I mean, I think the facts of this crime definitely show that this man is to his community. I mean, he committed unspeakable acts against the mother of his child. And I also want to say, as to the adverse credibility determination, again, that's totally a separately dispositive reason for denying this claim. And the claim is outlandish. He presented no objective evidence to support his claims. There's just nothing there.
Well, that'll just make the job of the IG real simple then. All you got to do is just look up there and say it's particularly serious crime, and that's the end of it. You don't have to even analyze it. And whether one wants to get into the morass of modified categorical and categorical, at the end of the day, we're talking about a definition and the use of common sense. That's all I'm saying. And it's a very simple thing for anybody to just look at the statute, then compare what's done here on the record to allow us to review it. I mean, there's a substantial evidence, but at the end of the day, it's really an abuse of discretion standard that we apply to the situation that we're dealing with here. So, I mean, yeah, we can go round and round and says he's a horrible person. He's done all of these wonderful things. All I'm asking and all I'm saying is that this may well fit in this case, but as cases go along, what is the principle we're going to rely upon for us to review these cases? And I'm simply saying the IJ needs to just do his job. It's a very simple thing. Look at the statute, compare it, give us the evidence that Judge Wilkinson has articulated, we can review it. But if the standard is simply, oh, it's a particularly serious crime, and then say nothing else. I think that we run into a real problem, and that makes review easier, not more difficult. And this is the kind of things, when we do this as an appellate court, we make these kinds of decisions, we send them back. What we do is we incentivize IJs and others to not undertake a serious review of these matters, because they can just say, well, those judges will just say it's a particularly serious crime. Look at all this evidence. That's all they need. It's a simple thing to do. And maybe if you send it back, that's all that's going to happen. But I think this record ought to reflect that. That's the difference of opinion we're having here. And we're probably not going to resolve it in this back and forth we're having right now. But I think that's the concern I have. And that is, these cases need to be treated seriously. There is a definitional meaning of particularly serious crime, not just your opinion, not just what the record all looks like. It may not be categorical if you want to get into the legalese, which we create these little terms and then they become like horribles, the categorical modifier. That's not really what it's about. It's about, tell us why this is a particularly serious crime. And you got a statute that's there, and what that statute said. Every state has different types of statutes and elements there. Now, if we're going to go off and board and do the whole type of shepherd look at every little element and what actually happened, that's a whole different ballgame. I don't know. But I'm saying at the end of the day, something more needs to be said, that it's just a particularly serious crime. That's the end of it.
Well, again, I understand your concerns, but I do want to point out that the adverse credibility determination is completely separate from the particular serious crime determination. And that adverse credibility determination, regardless of how you feel about the immigration judge's particular serious crime determination, the adverse credibility determination is totally dispositive of asylum and withholding of removal on its own.
I hear what you're saying. You know, I think there's a basic difference with my good friend Judge Wynn. No matter what IJs do, and no matter what the BIA does, there's always a process objection, always some way to just keep it going, do a remand. Obviously, process is important, but the question is, you know, when are these endless, picky process objections? When do we reach a point where when do they reach a point that as a practical matter, the process objections that are always raised in these cases, we review IJs and the BIAs, you know, with far more scrutiny than we do with lower courts. But at a certain point, I mean, process objections, they're important, and nobody wants a process which is sloppy and haphazard. But this isn't the case to insist upon a process objection in light of the credibility finding, in light of facts that had not brought into serious dispute. There comes a certain point when process objections just miss the main issue.
Well, and I agree with that, Your Honor. I think in this case, especially the Mr. Guevara got all the rights he was due under the statute. The immigration judge's decision is incredibly thorough. I disagree, Judge Wynn, with your belief that they didn't do enough at step one of the ambit determination.
Well, let me at least address that, because I think my good friend Judge Wilkinson and I do have a difference of opinion in terms of the role of an appellate court and how it influences IJs and trial judges. Our determinations of what makes the process difficult is when we're going back and forth and we all wishy-washy. Is this required or that required? If we are specific in terms of what we require, the message goes out very clearly. Guess what? The next case won't have this issue in it. But the kind of wishy-washy opinion, when you look at it and says, well, how do we determine this? And I do it. But my question really, aside from that difference, because that's just a difference that we're probably just going to harbor for a bit, and we may have to flesh it out down the road. But But the question I want to ask you is tell me that case that says an adverse credibility determination disposes of every other issue in this case. In other words, if you have an adverse credibility determination, does it dispose of every issue that deals with the cat denial? Does it dispose with withholding and NOAA type provision here? What is that case that says that?
Well, and I'm only talking about asylum and withholding of removal here because the particular serious crime determination doesn't go to CAT. I mean, he could still get CAT even if he's found to have a particular serious crime. But for asylum and withholding of removal, that's the statute, the INA.
But if it's not a particularly serious crime, what does credibility have to do with that?
Well, he didn't meet his burden for asylum and withholding of removal. Then it's still his burden to prove that he has a well-founded fear of persecution. But without presenting a credible claim, he cannot meet that burden. And that is in the statute. That is part of the statute. He has to prove that. That is his burden to prove. And that is something this court reviews for substantial evidence. So,
and how about the CAT claim? How does it affect the CAT claim, the adverse credibility determination, if you did not consider country conditions and other things that are there?
So the CAT claim, his past CAT claim, the past harm is all based on the same discredited testimony and evidence. Now, the immigration judge and board can and did thoroughly here consider country conditions evidence. But importantly to note, he has not proven that anyone remains interested in El Salvador since 2013. He has had no contact with Luis, the guy he fears.
That goes to one of the multiple problems with this case. We have a CAT claim, and that's insubstantial. He's removed to El Salvador, but every bit of the prior alleged suffering occurred in Guatemala. And as you just pointed out, the last personal interaction that he had with his persecutor, Mr. Diaz, was in 2013. He hasn't ever once reported assault to Salvadoran authorities. But the main thing is, and this was all analyzed, all the suffering occurred in a different country, and the persecution occurred years and years and years ago. And so with a CAT claim, you have to assess the likelihood of torture if he were returned. The IJ did that. He didn't just whisk it off. He did that, and she provided some very good and cogent reasons why the CAT claim collapses, because we've never recognized the standard of that someone's more likely than not to be subjected to torture when the last supposed incident occurred more than a decade ago, and where the alleged suffering occurred in a totally different country to which he's removed. You go up and down the line, whether it's the CAT claim or whether it's the asylum claim, they both suffer from serious infirmities.
And I agree 100%, Your Honor. And I imagine Petitioner's Counsel is going to argue that this letter from 2023 is evidence that they're still interested, but that evidence had no indicia of reliability. That's something that they have to prove, that the letter is reliable. The government was not requiring it to be authenticated, but this letter was allegedly thrown into his partner's or ex-partner's home, but she didn't even mention it in her own letter. The letter is unsigned, it's undated, it talks about a man named Marvin. There's no proof that Luis went by Marvin. So there's just absolutely no evidence that Luis remains interested in him. It is very important to note that all of the alleged harm occurred in Guatemala.
Maybe you should repeat for me exactly what the fantastical story he told about that formed the foundation of his asylum claim. Just mention it.
Well, I mean, he basically says he's in a garage and he sees coolers being kept beating by a contraption hooked up to a pacemaker. There's later a story that he's being shot at in a motorcycle crash. He falls, he somehow scales a wall, he's shot in the leg. He falls, crashes through the ceiling of a house, and it just happens to be his friend's grandmother's house. He hides under the bed despite bleeding profusely. The blood is pooling in his boots, but the guy comes and chases him in there but doesn't see him because there's a lot of stuff under the grandmother's bed. I mean, it's just a fantastical story, Your Honor.
So the whole business of having expert testimony and dealing with the vendettas and the longer periods of time, and we just ignore and we fall into, I think, we just forget about the Rodriguez Arias case that said that we can overturn the determinations of abuse of discretion if the IJ doesn't offer a reasoned explanation for its decision, or it just doesn't consider certain aspects of his claim. And it may look like we're picking and choosing through the records, but at the end of the day, all we keep doing is saying, do your job. But if the courts are going to increasingly just look at the result and we just say, well, you did your job good enough for us, and that's the end of it, we're going to continue to get sloppiness like this, where we do not get them to do essentially just follow it. If you say it enough, and if we say it consistently, follow what is needs to be done procedurally, process or whatever, and then when they come here, they're much cleaner to review. But the problem we run into is we sit up here and we sanction them with our wonderful, nice language of what is required, and we make it look like it's absurd. Go back and tell us how bad it was. And the real question is, did you do your job? Did you fail to give us a reasonable explanation? That's all I'm asking. Or did you not consider certain evidence, in this instance, an expert testimony? Not even mentioned. I think we're just at a difference of opinion in terms of what is needed in a case like this, and I accept the other side of it. It certainly can go that way, but I think as appellate judges, we owe more to, no matter whatever the case is, whether it's this type of case or any other type of case, we just simply are saying to those who are reviewing and trying these matters, do your job and do these things. And if you do them and they come up here, then the case is easy. It becomes difficult when we got to say, well, you didn't do it, but I can look at the record and see that you could have done it, or you would have done it this way. So, we can go back and forth, but Judge Wilkinson and I are having too much fun with this right now. So I'm gonna move on, Judge Wilkinson, and accept that you and I just agree to disagree on this little point here. How's that?
Mr. Lorenz, can you please respond to my harmless error question? If we disagree with you on the issue of credibility, that credibility is not dispositive or can't be dispositive, and we disagree with you and find that there was a legal error, is there another step that we are to apply in determining whether or not that error was harmless?
Well, I'd first like to mention to Judge Wynn, I think this case, the immigration judge did everything right, and the board did everything right. I think this is a very, very strong decision.
Your point is well taken. I think you should go ahead and argue.
Okay, and I apologize.
But in answering her question, tell her whether you briefed that or not.
Well, we didn't brief the issue of harmless error. I first of all would say there is no error in this case. This case is very well thought. This is very well supported. This is very well thought out. It's a very careful decision. This court can reach the issue of harmless error. I can say, I don't think, because of the adverse credibility determination, I personally, and this is just my opinion, I don't think anything would change.
We can reach it even though you didn't brief it, because you don't think it's your duty to prove it.
Your Honor, I don't think you should reach harmless
error. But I'm asking, but you said
I
want to make sure clear, because I want to be consistent in these cases. I've seen harmless error come up many times, and I know that there are standards that we hold to. You're telling me we can review it, but you didn't brief it. And does that mean you don't have the burden to come forth on it, or we could just do a record review?
Your Honor, we have no burden in this case. This burden is all on petitioner.
Not even on harmless error?
Well, and like I said, this was not an issue that's briefed. I don't think there's any reason
I accept
to reach
that. If you say it's not brief and you're just not pursuing it, I'm good with that. But to go in and say we can find it anyway, then that again is going to change the standard that I just wanted to be applied consistent across the board on these things here with other cases.
Well, I guess the question was asked, if you reach the issue of harmless error, we believe there was no error, but we don't think there was any harm in the error, because if it's sent back, I think it's clear from this record that the decision, the outcome, the denial of asylum is going to be the same, and that's my only point.
I'm just waiting for the day when I hear someone say, this is the IJ and the BIA really did a nice job with this. They were careful with it. They analyzed the claim. I never hear that.
Well, I think they did a great job here. I think this was a very well-reasoned, well-thought-out decision, and I think it's a great decision.
All I'm saying is that there's always a never-ending trail of process objections, and we have a pick that's more sensitive than my dentist's pick.
Judge Wilkinson, that's because we don't get the cases in which they do an excellent job on. We get the cases in which there are questions as to whether they did it. And the vast majority of these cases never get to this court. And you know it, I know it, and everything. But to pick the few out and says, I'm waiting to see a case like this, they don't appeal those cases, so you don't go anywhere with those cases.
Well, I have learned with my dear and good friend that the retirement is the better course of valor.
Agree.
I should leave you with not with in a spirit of final harmony on the result, but that I realize the wisdom, my friend, of giving you the last word, because you always have good points to make, invariably and always. And I love sitting with you. I'm going to ask Judge Berner if she has further questions. And Judge Berner, do you have any further questions of Mr. Lorenz?
No, thank you.
Thank you, Your Honors.
All right. Now, Ms. Rosenbaum, you have some rebuttal time, and we'd be happy to hear from you in rebuttal.
Yes, Your Honor. I want to start with Judge Wynn's question, who is looking for a case from Mr. Lorenz about adverse credibility. And in fact, we have the case. I don't believe it says what Mr. Lorenz claims it said, but it was cited by the IJ, comes from this court. Russo v. INS, adverse credibility determination is likely to be, but not necessarily, fatal to an asylum claim. And I think that goes to the point, Judge Wynn, you were making earlier that we completely agree with, that there may be speculation as to the outcome, but what we know for certain is that there was legal error committed by the IJ, the BIA in this case. And then to go to Judge Berner's question that was asked earlier about harmlessness, there is no harmlessness requirement in this case, in this precedent. None exists. And in fact, this court's precedent in Anor, there was a plaintiff who not only had a PSC determination, but in fact, the IJ in that matter reached the merits of the withholding of removal claim, which RJ did not reach the merits of either the asylum or the withholding of removal claims, because after he found the PSC determination, he said there was no need. So in Anor, it was even further. They had decided the merits of the withholding of removal claim, found that the plaintiff there would not have met his burden for withholding of removal, regardless of the PSC determination. And still, this court vacated and remanded because there was legal error in the PSC determination, which is exactly the same legal error that we find here at step one. And I also would be remiss if I didn't bring up the legal error that we find in step two that has not been addressed yet today, which was the agency also committed legal error in failing to apply its own law and binding precedent in matter of Juarez. Juarez involved a petitioner who was convicted of a misdemeanor offense of assault upon another with a deadly weapon. The BIA in Juarez overturned the IJ's finding of a PSC, explaining that except possibly under unusual circumstances not present here, a single misdemeanor conviction is not a PSC. The BIA in this instance failed to explain how here, where there is a single misdemeanor offense that constitutes a PSC, whereas in Juarez, a single misdemeanor conviction for assault with a deadly weapon was not found to be a PSC.
You know, I haven't heard you dispute the facts here. I haven't heard you dispute that there was a protective order that was violated. I haven't heard you dispute that he was going to rip out the petitioner was going to rip out a contraceptive device implanted in her. I haven't heard you dispute that he gripped her hair and violently threw her to the ground. I haven't heard you dispute that the police actually witnessed some of this behavior. I haven't heard you dispute that there was fresh bruising on this woman's arm, that the bruising was in the shape of fingerprints, and on and on. And all of this on a person whose basic defense was that, he was just trying to help his partner. That's a strange way of helping somebody, a very strange way. And you have to ask yourself, it's Congress that passes these statutes, and you have to ask yourself, is someone who is treating women that way? We have a serious crisis of domestic violence in this country, and you have to ask yourself whether Congress wants someone to be free from deportation after committing these sorts of acts. And this is the end of it. And why in the world should someone like this individual get asylum when, in addition, it's generous to say that he has an adverse credibility problem? That's a generous phrasing of it. He lied.
Vincent, may I answer your question? I see I have 3 seconds.
He lied through and through. You may have some time.
Thank you so much. I want to link this back actually to your earlier point where you wanted to hear about an IJ being careful and doing a good job, that those are phrases you'd like to hear. Some of the the alleged facts that you just stated don't actually go to the PSC analysis that was performed. They go to the violation of the protective order, which the IJ did not reach at all in his PSC determination. And I think that goes to the heart of matter of why the legal error here is so important. When we don't know what we're analyzing, what we're looking at, how do we know what the proper test for the PSC, what is the legal standard, if we're not even sure what we're analyzing? And I think had the IJ done a clear job following the legal standard with the two-step framework, elements only at step 1, having to apply Juarez, which is binding precedent, explaining a single misdemeanor conviction, I think then there may be a different situation, but that's not the scenario where we are. We are here with a record where the proper legal analysis was not performed, and at that point—
Excuse me, counsel, you said you don't know what we're looking at. I know exactly what we're looking at. And the danger here in these situations is we miss the forest for the trees. And the forest here is the question of whether someone should be granted asylum and a protected status in this country, engaging in what can only be characterized as very predatory behavior. But that, it seems to me, is what just hits me front and center. Ms. Rosenbaum, do you have a final comment you want to make? I like to give advocates a final word.
Thank you, Your Honor. I do have just one final, you speak about the forest for the trees, and we still maintain that the forest here is the proper functioning of the system, applying the proper legal analysis for good rule of law, such that this case needs to be remanded to issue a decision with sufficient analysis to fulfill the agency's legal obligations for a reasoned decision. Thank you, Your Honor.
We're here with the eternally deficient process, the eternally insufficient explanation, over and over. Well, I want to thank you both for your presentations, and as I mentioned to the attorneys in the last case, we're not here in person. We couldn't come down and shake your hands, but we can sure as heck appreciate your presentations for the fine arguments that the two of you have given us this morning. And we will now take a brief recess, about 5 minutes, and come back.
This honorable
Hear our
court,
third case, okay?
this honorable court will take a brief recess.
I'm moving the attorneys in the waiting room.
very good. Mr. Carlisle, I think you're up first, aren't you?
Yes, sir.
Okay.
Good morning.
Why don't you go ahead?
Thank you, Your Honor. Good morning, and may it please the court. My name is Corey Carlisle, and I represent the appellants in this matter. We're here today on a relatively limited question, but one that is interesting, particularly in the way that we I think define the boundaries between 12b6 practice and summary judgment practice on a state law West Virginia conversion claim. This lawsuit, and I think a little background may be helpful that wasn't in briefing. And my client he drills for oil in West Virginia and creates these partnerships to complete each project. And so that's the genesis of the accounts in this case. We got 4 or 5 different accounts here, and so that's the reason that
But
this
your
thing
problem it seems to stem from the fact you got some accounts that were set up a long time ago, and now you don't like the way they were set up.
That's exactly.
That doesn't. I mean, and the question, the conversion type. I guess that's what we're now dealing with is the question of the conversion. And I think the conversion is what you say the bank did here, not at this time, not what it did back then by putting it in a different one. Is that right?
Yeah, it's an interesting case, and I think very unique case actually, and because the West Virginia
because
state,
most people would not have an account set up with this kind of sophistication and leave it for years and years, and then come back and claim that it's a different type of account than what it is. I don't know what the bank. I don't know what the bank was to do. If you got an order, you had an order from the. What do you think the bank's going to do? If you get a court order, tells them transfer this money. Seems like to me you need to sue the court or something, or go and find out get that overturned. I don't know, but I don't know what a bank does. If that bank had not done this, that's a problem. I think, don't you?
I do, and I think Your Honor's hit exactly on, frankly, part of the issue with the very strange facts of this case, and certainly something that if you know Your Honor was in the war room trying to figure this out at the time the complaint was drafted, something that I imagine came up. I wasn't there, but. What I would say in terms of what was the bank to do, because I think that's a pressing question. I think it's a good question. You know, what is a bank to do in this situation?
I think anybody that represents a bank want to know that answer.
Yes, sir.
And certainly the bank. I want to know at the end of the day, what do you think that bank should have done here? That's different. That it had a court order. I don't know what. That to me seems to be dispositive almost right there. And I know it's not, but it just feels like it ought to be. From the bank's perspective.
Well, and I think that's why I think that's a summary judgment question. I think that's for that determination to say because as I said at the beginning, I think what we're doing here is limited. And as we know from West Virginia state law, there's no requirement of bad faith on the bank's part. This can be done in good faith, and we've not alleged, at least to my knowledge,
it's more than good faith. It is done under an order.
Correct. That's right.
I don't know what the good faith is. It doesn't matter whether you don't have a choice on that, good and bad faith or whatever. You gotta. I mean, the court sends you an order. What are you gonna do?
Well,
you either appeal that order or get it stopped, or you go and get an injunction on it. But then after the bank transfers it and says, "Well, you converted our funds." I guess I'm gonna leave that alone. Maybe I'm the only one that has that concern, but it troubles me just. Generally, before we even get into the morass of legal issues here, because we can talk conversion, we can get into, what the facts were back then and whether he's an oil man and all of that. But I'm really stuck on this thing on just the bank itself. But go ahead, and I probably taken away too much of the time on this concern of mine. But I wanted to throw that on the table because I didn't want it to be on my head. And I'm sitting here not listening because that's still in my head. I want you to get that off of my head so that I can get into your argument.
Understood. Well, it's the court's time.
Before you move on, because and I think Judge Wynn asked a question, which if it's not properly answered, that's to me the end of the case. You have Dale or Drillco that's listed as an account owner on each of these accounts. and then the judgment was entered against Dale and Drillco, and Peoples was justified in paying over $100,000 to the joint creditor from the accounts. It really has to do this because it was the names on the accounts were the same names that the people against whom the judgment was entered. And the question is, does the bank follow the rule of law or does it not? Because the West Virginia State Court has issued a suggestion and writ of execution. And it just seems to me that if the bank is going to follow the rule of law and be properly respectful of a judicial order, or in the suggestion and writ of execution here, had the bank refused to honor the court order and refused to honor the judgment, it would have been in a heck of a lot of trouble. And so not only did the bank not commit an error, it seems to me that the bank proceeded along a perfectly lawful and honorable course.
Yeah, I think that the answer to that question, it's subject to, we view that as more of a merits question, but I understand the court's concern at this time. I think the bank could have done something like an interpleader and asked for a determination on this particular issue and bring the issue before the court and say, look, we think we should give you the money. Dale and Drillco says that we converted. Let's have that determination made and go through it that way.
How did the bank enrich itself? I don't understand. I mean, normally when somebody is engaged in a conversion, it's ordered to enrich themselves in some way. But were the bank's actions here, did they redound to the bank's benefit? Did they enrich the bank in some impermissible way?
Yeah, my response to that would go to the Rogers versus Rogers case that we've cited. It's a 1990 West Virginia Supreme Court, that it is not necessary that the wrongdoer apply the property to his own use. And so that
But I'm saying I think it's a very relevant question. It was what you're asking us to do overall is to evaluate the bank's behavior. And Judge Wynn asked you the question, what else was the bank to do? And that was the same question that was in my mind. What was it to do other than to honor a court order? And so yes, it's relevant. If the bank had enriched itself, to me, you would have a stronger case. And you can point to the elements of the case and what conversion requires. But the fact is, without any profit on their part, they honored a money judgment issued in Texas and a writ of execution issued in West Virginia. And they did what they thought quite reasonably the law required of them.
Yes, and I think part of this also is tied into how quickly this happened in terms of, in the second part of the brief that we talk about the 21 days and how this happened within 9-10 days from the suggestion to the checks being issued. And in that way, these are just different bases for the way that the number one, the speed with which this happened. Okay, and so the bank did not respond as it, I think, could have with, hey, court, make a determination for us. We don't want to make the call on should we have to pay this, should we not, in terms of, because Hugh Dale is saying that the funds are not subject to execution because they belong to some other partnership. That's one option at that time. And as I say also, this is, I think, such a one-off case, such a very strange case. No business owner wants to go through this in order to get their money back. As the court can see, it's not a lot of money, yet it's very meaningful. And my client has had this money and it's sitting there for now, kind of a long time for this amount of money to be gone. And so I don't think there's an incentive for people to just lay behind the log. If this court comes out with an opinion that says we have stated a claim. Moving the case forward beyond that, maybe we have factual development, maybe other things can cement this. I think, and I don't mean disrespectful, I think a feel, and I think it's a valid feel that both your honors have expressed in terms of, is this really a cause of action? The district court can deal with that at a merits phase, but insofar as we're just at the statement of the claim phase where we're crediting the things in the complaint that are stated.
Doesn't Twombly and Iqbal require us more? I mean, what you say makes sense, but as I understand, there was a reply, at least maybe when they answered it, they appended that statement there to it. It seems like even at a motion to dismiss stage, something more is required here. That if you don't dispute that those accounts are in those names, and they did what the order did, seems like something else ought to, I think, before Iqbal and Twombly, I probably would say, yeah, all you need is notice on this thing and there's nothing else. But I think it's given a different standard, at least for these kinds of cases.
Sure. I mean, I think if I hear you correctly, then where we're talking about, Judge, is maybe what we talk about, like the line between possibility and now where we're at with plausibility under Iqbal Twombly. And this is a difficult line to draw at times. And I suspect part of the issue, the ongoing issue with the way that that standard was heightened by those two cases. That said, the issue about the names on the account, the tax ID or social security numbers that were on the account at the time, we've got what we've stated in our complaint, but we don't have a deposition. We don't have, here's how, exactly how this conversation went down in my recollection. We don't have the full extent of what bank records I think we might have. What we do have is a legal issue, and I think we have a legal issue that's been presented to the court below, that's presented to this court, that this court can evaluate strictly on legal terms. Now, we come to these cases with some regularity of, is that really going to get anywhere past 12b-6? So I think the futility concerns that I hear the court expressing, in our view, the way that we've worded the complaint in terms of Mr. Dale's stated instructions in the past of create them this way, and then the failure to create them that way, those are the underlying things that just sort of sat dormant for some time, as we see 15 years or 10 years, however long. And those conditions that created this later possibility for a conversion claim really just sat there for a while, sort of like maybe a testamentary interest. Grandpa says, I get the car. Well, Grandpa doesn't die for 20 years. And then, that right springs into existence, at the moment of passing.
It just seems like there's another way to do this. This doesn't, the concern is, I don't know what the bank is to do on it, but it seems to me there's another way. If you got an action against you and you got a judgment, you got these accounts. It seems like, those who have the accounts want to make sure that's not part of what can be executed here. And probably in the state court is where you would bring this back to make sure that these accounts are exempt, or you appeal it and says, no, you can't issue this order against this or something before it gets here. I don't know. It's a strange animal you bring to us, and I'm just you mentioned that, but I don't think I've ever seen a case like this. But tell me another case that's like this.
I can't, but here's what I think is interesting, and I think counsels for reversal here, and because looking at the court's order, the district court says pretty clear reasons for failure to state a claim on our other original claims. Okay, negligence, statute of limitations, it's done. Okay, this is a legal matter. We see it from the record. We haven't brought that issue on appeal. Fiduciary duty, the court says a banking relationship does not create a fiduciary duty. Okay, we haven't challenged that on appeal because there's clear case law from the state. And then the FDCPA, the statutory definitions there, just they basically, there's no way to plead into those in the facts here. And Judge Wynn, you touch on the frustration of bringing this particular matter to court and to try to find some redress for my client. This claim is the only one that doesn't contain, in our position, in the district court's opinion, a clear categorical reason why it ought to be prohibited, just in terms of how we stated a claim. And so for that reason, we asked the court.
Then it looks like a negligence runaround. It looks like you might be bringing a conversion because you can't bring a negligence claim because the statute of limitations on it.
Well, that's just the nature of the beast here, I suppose, because that you know, as we said, the negligence just sat there, and unfortunately for Mr. Dale, this judgment happened and everything that's come from it, and so I think it's a unique claim, and in any event, for the reasons we've stated, we asked the court to reverse and remand the case.
All right, thank you very much. Mr. Spitz?
Thank you, Your Honors. To start with, something was done by the plaintiffs in this case to fight or protest the transfer of the money to the judgment creditor. They litigated the validity of the judgment, and that is noted in the record. It's noted in the district court's order. Joint Appendix 169, footnote 2, discusses the fact that there is now a West Virginia Intermediate Court of Appeals opinion discussing the validity, which was challenged, of the debt and the collection of the debt. And so the West Virginia Supreme Court has addressed that issue in terms of the validity of the underlying judgment in Texas and its ability to be domesticated and enforced in West Virginia. The West Virginia Supreme Court has also addressed a situation, not directly on point here, but it's addressed the situation of, does the judgment debtor, which would be the plaintiffs in this case, who owe, debt on a judgment to a judgment creditor, do they have the right to say to a person who has received a suggestion, you have to stop, you have to wait, you cannot comply with that suggestion because we think there are issues with it? The answer to that question is no. They do not have the ability to do that. And that is from the West Virginia Supreme Court case of Van Scoy versus Neal, 322 Southeast 2nd, 37. And it says, the third party who receives the summons may either answer the summons and await service of a court order before releasing the property to the clerk, or it may deliver the property before the return date of the summons. Under the statute, the judgment debtor is not entitled to notice of his exemption rights, nor is he given an opportunity to claim his exemptions before the third party's surrender of the judgment debtor's property. And that's what's happened here. The bank has surrendered the judgment debtor's property in response to the suggestion and complied with West Virginia law by doing so. And the fact that the judgment debtor or other entities have objections to that does not cause compliance with a lawfully issued summons by the clerk of the West Virginia court to be inappropriate in any way, shape, or form.
You're saying that the vehicle by which the plaintiffs here should try to assert their rights are in bankruptcy or in some separate proceeding, going back to the Texas courts, or try to amend the judgment or alter the judgment, and then try to retrieve the funds. So you're saying that there are a variety of other mechanisms that were open to the plaintiffs if they wanted to get the money back, including bankruptcy and a return to the Texas courts or whatever. Is that correct?
Yes, Your Honor. And to the point in this case, Your Honor, the real wrongdoing that was alleged in the complaint was the setting up of the accounts, right? And setting them up as joint accounts rather than as a partnership account.
Well, I think there's also an allegation that the bank was under an obligation to allow Mr. Dale to respond to the suggestions, to provide
Yes.
some opportunity to respond. That's a second claim, or second legal argument, at least.
Yes, Your Honor, and may I address that?
Please.
All right, so that legal argument is based upon an incorrect application of the statute and of the rule. The argument that is advanced by the plaintiffs is that the plaintiff has 21 days to respond to the suggestion. That is incorrect. It is the person who receives the suggestion, which would be the bank. The bank has up to 21 days to respond, and the bank is permitted to respond in advance of that time, and it is permitted to respond in advance of the deadline pursuant to statute. West Virginia Code 38-5-14 permits the bank to directly send money to the judgment creditor on or before the date that the suggestion comes due, which is the 21 days. The misapplication or the fallacy in the argument advanced by the plaintiffs is that the plaintiffs contend that in the application of the statute, plaintiff is the person. Plaintiff is not the person that is referred to in the statute. The person referred to in the statute is the person who receives the suggestion. And that person in this case is the bank. And so the bank, under statute, once it receives the suggestion.
What case are you relying on for the point that person in the statute is the individual that receives the suggestion as opposed to the individual that lays claim to those assets?
Your Honor, I'm not citing a case, it's the statute itself. It would be 38-5-14 and 38-5-10. And those two statutes use, it said a person suggested, which would be the person that would receive the suggestion, may at any time before the return day of the summons deliver the property or pay the money for which the person is liable at the time of service of the summons, or a sufficiency thereof to satisfy the execution, and shall thereby be discharged from any further liability. And so the argument advanced by the plaintiffs does not fly because their argument says that they assumes is premised on an assertion that they are the person who is given up to 21 days to respond. That assertion is incorrect. The person who's given 21 days, up to 21 days to respond, is the person who receives the suggestion. And the record is clear that the person who received the suggestion is the bank. Does that answer Your Honor's question?
Yes, thank
you. And so looking at the complaint, and the reason why the complaint at this point fails to allege a cause of action for conversion, which is the only cause of action that is being appealed, I suggest to the court that the key paragraphs of the complaint which demonstrate why the complaint does not state a cause of action for which relief can be granted is paragraph number 41. And paragraph 41 alleges that the accounts were created as joint tenancy accounts. So that's the fact that's alleged. And then paragraph 96, which is an allegation or a conclusion of law, which is that the defendants had no legal right to divert or dispose of the assets contained in those accounts. While we have to accept the facts as true, we do not accept as true the legal conclusions of the plaintiff. And that legal conclusion, not in paragraph 96, is wrong. And it's wrong because of the factual allegation in paragraph 41. Because these are joint accounts, they are subject to being levied via suggestion for debts that are owned by any of the individual owners of the account. And as such, when the bank responds to the suggestion that's lawfully issued by the clerk of the West Virginia court, the bank is not acting without a legal right. The bank, in fact, at that point is compelled by the law to turn over the assets that it has under the name of either Hugh Dale or Drillco.
Well, what are you suggesting that what recourse do you suggest that the plaintiffs have here if they wanted to protect the funds in their account? What do you suggest? I know we've talked a lot about what the bank's rights are and what the bank is doing, but what course of action do you think that these plaintiffs should have pursued?
The plaintiffs could have sued
if they wanted to protect the funds in their account.
The plaintiffs, well, starting off, they could have appeared in the Texas action and defended the Texas action. They could have appeared and defended, which they're trying to do. I don't know if in West Virginia, we have a decision from the Intermediate Court of Appeals in which they were trying to defend. That can be subject to an appeal to the West Virginia Supreme Court. I don't know if they're pursuing such an appeal. And they can potentially bring, if they think these funds have been wrongfully taken by the Texas entity, Signal, they could sue Signal for conversion. If they think Signal is wrongfully in possession of their funds.
So what you're suggesting, though, is that the plaintiffs needed to go back into Texas court to alter the amount of the fact of the judgment or take an appeal in the Texas court, or that they return to the West Virginia court and try to find some problem that would have forestalled the writ of execution, but that they should go back to the courts in Texas or West Virginia to straighten it out?
All of those are
They
options.
could have done it. Is that a realistic option for them?
I don't know at this point if it's a realistic option for them to bring a new suit against Signal, given the passage of time and the application of a potential statute of limitations to a conversion claim. I don't know if they have a realistic option. But but I mean, if they feel that there's an unjust withdrawal or an unjust claim on their accounts, is this, you say, well, they could do something with the Texas action, but that's already been litigated. And the West Virginia Supreme Court is probably engaged in sort of a ministerial action in just carrying forward the Texas judgment. But if they really feel that there's something, that this is a wrongful withdrawal here, I just wonder how they could protect themselves. I'm not sure that at this point in time they have a viable option to do so. And I think that would depend upon perhaps if they were to file suit in Texas, what the statute of limitations in Texas would be for asserting a conversion cause of action against Signal were they to do so in Texas. And I don't know the answer to that. They can also, the partnerships can also sue Hugh Dale personally for negligence in his setting up of the accounts. Right now,
your basic view is that the bank shouldn't get swept up in this, in all of this. That whatever the issue is between their adversary in Texas and whatever the issues are before the Texas court, that's for Texas to decide, and that's what the Texas litigation should have decided. But once the judgment reached the West Virginia court, and once the writ of execution was issued, your view is that the West Virginia court had very little that it could do upon hearing from Texas, and that the bank had very little that it could do upon receiving the writ of execution. That the real playing field here was all the way back in Texas, and that the subsequent steps were almost ministerial. Is that correct?
Yes, Judge. And to be, I guess, gracious to the plaintiffs in this case, I think a fair thing to say also would be the real playing field is way back in the early 2000s when the accounts were created, and whether or not they were created in accordance with the instructions of Mr. Dale or were potentially negligent. And that playing field is not open to anyone at this point because of the passing of the statute of limitations and the fact that the negligence cause of action is not being appealed. And so to try and keep what really should be a negligence claim alive, the plaintiffs are pursuing a cause of action for conversion because the complaint was filed within 2 years of the date that the bank responded to the suggestion. And so that's the only act that took place by the bank within the 2-year statute of limitations. And that's why they're...
I understand all that, but the real question, even apart from the statute of limitations, is that what we are dealing with is the enforcement of a judicial judgment, and the fact that neither the West Virginia court nor the bank wished to make itself a party to the frustration of a judicial judgment, and they didn't want to interpose themselves as a bar to the execution of a court judgment. That it seems to me is what it all comes down to, is the enforceability of judgments, and whether we want to build into that process various causes of action and bars and hurdles and everything. I mean, I think that society has a general right, and courts have a general obligation to see that the enforcement of judgments is being carried out without all kinds of causes of action being brought against intermediaries. And what's happening here is that they're trying to obstruct enforcement by attacking intermediaries. And that just can't be right.
I agree, Your Honor.
But isn't that what really is at stake here?
Yes, Your Honor.
Let me ask my fine colleagues if they have a question for you. Judge Wynn?
No, I do not, Your Honor.
No, I do not.
All right. We thank you, Mr. Spitz. Thank you so much.
Thank you, Your Honor. Thank you, Judge Wynn. Thank you, Judge Berner.
All right. Mr. Carlisle?
Yes, Your Honor. A few points, maybe go with what y'all were just talking about. And I think that we can't categorically say a bank can never be wrong to execute on a judgment. There are many facts. I said that wrong. Can't categorically be wrong in answering the suggestion without availing itself of certain other remedies like an interpleader and asking for someone to make a determination. Second, I'll go to the West Virginia procedural rule on suggestions. That was 38-5-10. And I think what my friend could have pointed out, and I would point out, is at the very beginning of that statute, Section A of that, it has two qualifying phrases. Upon a suggestion by the judgment creditor that a person is indebted or liable to the judgment debtor, that's one. And then two, or has in the person's possession or control personal property belonging to the judgment debtor. And so at the beginning of this procedural statute, it's not just the person holding, the bank is holding. You might say Dale was holding it in an account, but either way, he was, the number one part of it is he's indebted in terms from the Texas judgment. And so that's part of our interpretation of that rule and part of why we suggest that applies. As with my friend, I faced the issue of not being able to bring the court a case to tell us what this statute means any more than us looking at the text here and banging 5 heads together to get an answer. But
the suggestion itself is a suggestion to the bank.
Yes.
As the judgment, as holding the funds. And so it seems it's upon a suggestion by the judgment creditor that a person is indebted or liable. So the person, how do we not read that as the person referring to the bank?
I think that the suggestion by the judgment creditor maybe says both in a way, in terms of Dale is indebted and bank, you hold in your possession the property. That's how I would answer that question. Going to the pleadings, my friend identified 2 paragraphs, 41 and 96 of the complaint. And I'm not certain that the suggestion that the argument is that we've had pled an admission there in terms of 41 saying that the accounts were originating as a joint tenancy. That seems to be what is on paper for now, but as we allege, that was not what we had asked for at that point. I've moved to the issues of sort of what to do. There's been a lot of talk about that. As I said, of course, I think the bank ought to have availed itself of procedural legal option like an interpleader. We are in Texas State Court currently litigating a procedure called a bill of review here that we're within the timeline to do that. It's within 4 years of the judgment. That's happening right now. That is one of the things we're trying to do to get all of this undone, because this was the underlying judgment in the beginning was a default judgment, and we have some service-related arguments under Texas law to try to undo that, which, as Judge Wilkinson suggested, would perhaps allow us to get back at these monies and to solve that issue that way. I think the final thing I would note is we didn't have a conversion claim until the cashier's checks were issued in this case. We had nothing. We had a judgment, there was enforcement efforts, execution efforts, but under West Virginia law, this cause of action does not accrue until that act takes place. And so,
well, but you're not totally blameless in all of this, because you were the one that set up these accounts in this name, and you're the one that litigated the case in Texas, and it really. Once the account was set up in that name and the judgment was entered in Texas against the account owners, at that point the die was cast. The writing was on the wall. Your real opportunity was to litigate the Texas case more successfully. But that didn't come about. And you're upset that you're stuck with a $100,000 judgment, but that's not the bank's fault. And the bank shouldn't be complicitous in the fact that the Texas litigation did not turn in your favor. That's my whole problem with it, is that it all traces back the fact that you lost $100,000, but you lost $100,000 due to the outcome of the Texas litigation. You didn't lose $100,000 as a result of something that the bank did. That's my problem.
And Your Honor, I think I fully expect to hear all of those arguments from the bank at summary judgment, and we can fully address those. I think what I can characterize as merits-based arguments at that time.
Okay, thank you. And but this is in some ways, this is a collateral attack on the Texas judgment. It just doesn't sit well with me. but I'm going to ask Judge Wynn, Judge Berner, do Do you all have any questions of Mr. Carlisle?
I do not.
Judge Byrne, you okay?
Yes, thank you.
All right. I want to thank both of you for your arguments here today, and we appreciate it. And I said it to in the previous council, it would be awfully nice if we could come by and express our appreciation personally with a handshake, or these days, I guess, a fist bump is probably appropriate. Just want to say to you both, okay?
Thank you.
Thank you all. Have a good afternoon.
All right. So we're going to get into our last case here, and Mr. Golinczewski, we'd be delighted to hear from you, sir, on this Covington case.
Thank you. Thank you very much, Your Honor. John Golishevsky on behalf of the appellants, and may it please the court. I'd like to address three separate reasons why the district court erred in its duty to defend analysis. The first are the very clear allegations sounding in defamation and disparagement, which triggered coverage under subsection D of the personal and advertising injury coverage Omega purchased. To it, quote, oral or written publication in any manner of material that slanders or libels a person or organization or disparages a person or organization's goods, products, or services. The district court's conclusion was effectively that plaintiffs had alleged nothing in the underlying case that would give rise to a defamatory implication, and with respect, that simply ignores the black letter of the underlying complaint, paragraph 140, quote.
Let me ask you a preliminary question so
Sure.
I understand the posture of this. And you have explicit counts under the complaint, the right of privacy, the business conspiracy, a couple of Langham Act accounts on false advertising and false association.
Correct.
And you are now pointing to the potentiality aspect of it, of those claims potentially that could be brought. I guess one would be the misappropriation of advertising ideas, but you focused on, I think rightly so, the defamation by implication. And you say there's a duty to defend because under Section D, is there, and there's no exclusion to it, and it's not been waived, so it's covered. And what the question that comes to my mind, I think you might be headed in the right direction in terms of that, but and maybe the case law goes there. I just need to be clear on it. This matter was settled, and then you have the explicit claims here of the settlement. Did the settlement include this claim, or it was settled based upon the complaint, and I'm wondering to what extent do we look at the potential claims once a settlement has been issued? If you follow me on that, it's almost like you could have brought these claims of potential there, but they're not there, but you settled it, and it seems like that would be the end of it, but you say, no, you should come and pay my attorney's fees because I had a potential claim of defamation. And by the way, you didn't bring up the right of privacy thing, but I might have been moved by that, but that's not before us. You didn't bring that up. So now you see where I'm going on it?
I do, Your Honor, and I think
because you jumped right into where the one that I thought that maybe, yeah, you do have something on it. Yeah, that was pretty wise. That's what but you didn't talk about the other ones, which I don't think there's there on that, but it may be here. And if you prevail on that, get me to how a settlement, case where settlement happens, and these claims can be considered in terms of representation, the duty to defend, such that now you can recoup the attorney's fees that you've gotten on it.
I thank you, Your Honor. I think the short answer is that when we're talking about the duty to defend, we're talking about the four corners of the complaint, and we're talking about the four corners of the policy. And anything that happened after that, anything Omega needed to do to preserve its interests in light of this denial by Covington, is not material. And to be clear, it doesn't just say defamation, it says defamation or disparagement. Again, Covington held the pen there. They decided to say defamation or disparagement. And when you're just looking at the 8-corner ruling, you're looking at the complaint and the plain allegations, and when the plaintiffs in the underlying case allege defendants' illicit concerted efforts due to them, quote, each of the plaintiffs' reputations was injured. To me, this is a pretty open and shut case of a defamation by implication claim. And what happened years after the fact, and any settlement that went on, and anything Omega needed to do to protect its interests, has no bearing on the operative question that was before the district court, which is what is Virginia law, what does the complaint say, and what does the policy say?
That's the central issue for me, and that is, at least from my perspective, if I were to assume that, okay, yeah, there was a duty to defend that claim, but I just want to be clear on this fact that that's not explicit in the complaint that was before the parties when they chose to settle this matter. And by having this claim, this potential claim out there, the expansiveness of the duty to defend says, well, because I potentially had this claim here, you now pay for my attorney's fees on that right there. And I'm wondering in the settlement of, I guess, because this is the insurance company that's paying it, and you were not part of the settlement on that thing there.
To be clear, Your Honor, I was personally part of the underlying settlement. I can't speak to, and I don't want to misquote exactly what that settlement was, but I would imagine the settlement was, and we can, I don't think it's in the record, but of all claims or potential claims.
You just opened another question that I probably got, is your role in this thing here. You sort of switched hats a little bit here. Did you?
That's exactly right, because as part of the settlement, all claims that Omega had against Covington were assigned to the underlying plaintiffs. So thus, we are now, my clients, the underlying plaintiffs, are in the shoes of Omega. So that's how that sort of switch occurred, Your Honor. In addition to the defamation by implication claim, there is a clear claim of defamation per se, because when you're looking at defamation per se, the question is whether or not the statement made by the defendant could tend to injure the underlying plaintiff in her career or her profession. The district court's position was, I think, a little, with respect, confused on it, but we point out the Edmondson case from the Southern District of New York. I didn't want to turn that. I want to get in terms of representation a little bit, because it's still, maybe I was just trying to process what you were saying. Sure.
But I thought you represented the Geiger plaintiffs in this thing at one point, didn't you?
We absolutely did. We represented the Geiger plaintiffs in the underlying.
But you're saying that the interests of Omega and Geiger are now the same?
Well,
and that Omega has no real interest in defending the duty to indemnify anymore?
No, it absolutely has a interest. The interest has been assigned to the underlying plaintiffs, to the Geiger plaintiffs. That was what the assignment said, pursuant to the settlement agreement and the consent judgment in the underlying litigation.
Let me ask you, what is there to do? Let's say we said there was a duty to defend. What would you be defending at this point?
At this point, Your Honor, there is no active case. The question is, what is that duty to defend and the breach thereof? What is the value of it? I.e., Omega had to pay significant monies in the underlying case. They had to fight the deck action brought by Covington. They had to settle the underlying case, and litigate the underlying case. Covington absolutely did provide a defense for a portion of that time, but there are monies that Omega certainly had to pay out of pocket due to directly as a result of Covington's breach of its duty to defend.
Okay, so you're saying that if there's a breach of the duty to defend, and there's a later settlement, that and there was no defense during the settlement negotiations, that the party that defaulted on the duty to defend is liable for damages. What's the remedy here? Because normally in these duty to defend cases, we're looking at it going forward.
Correct.
Saying that, well, you have a duty to defend, and then we look to we sort of look to the future, and because these cases normally come up to us prior to trial.
Yep.
And what makes this curious, in my view, is that I haven't dealt with too many cases that say that if there's a default in the duty of defend, and this is post-trial or post-settlement, what is the remedy here? What do you think you would do if there's a violation of the duty to defend? How do we measure the damages here? Because it seems to me aren't you in a bit sort of skating beyond the duty to defend and over into the duty to indemnify?
Which we may very well be, Your Honor. The problem is that the district court never got into the duty to indemnify. There's a $155,000 consent judgment.
But aren't you really? Doesn't this case really pose, in terms of the remedy, whether there is a duty to indemnify and how much that is?
I think it does both.
Okay, but what you're saying is, in order to resolve the remedial question here and the question of damages, that you're saying as a threshold matter, we have to resolve the duty to defend, and if we hold that there's a violation of the duty to defend, you're asking us to remand the case for further proceedings. Is that correct?
That's absolutely correct, Your Honor. And I'm sorry, Judge Wynn, if you had a question.
Well, I was just asking about the duty to indemnify.
Sure.
Omega doesn't have a duty to do that. I mean, that's gone, right? They have no interest in defending a duty to indemnify anymore.
I don't know if that's accurate, Your Honor. There's a judgment that was entered against Omega. Our position is that if Covington breaches duty to defend and breaches duty to indemnify, then among the damages to which which Omega would have been entitled to is a defense or payment of that.
The settlement agreement stripped Omega of any obligation to pay any money to those plaintiffs. So there can't be any duty for Omega to have to no duty to indemnify Omega in this action.
There is a legal obligation that Omega has on that judgment. The fact that the plaintiffs, as part and parcel of the settlement, agreed not to enforce that judgment as against Omega does not vitiate the judgment obligations.
Just to be clear, I will make sure. Does Omega have an obligation to pay anything at this point in light of that settlement?
As per the terms of the settlement, the Geiger plaintiffs have agreed not to enforce that judgment against Omega.
So answer my question, because it's very important to me to understand that on indemnification. I think duty to defend is totally separate. But I think that the indemnification, I don't see an illegal obligation for Omega to pay anything. Is that true?
Omega has a legal obligation as per the terms of the judgment. That legal obligation has been excused as per the terms of the settlement agreement because the Geiger plaintiffs agreed not to enforce it against
Translation, Omega doesn't have to pay anything.
Correct. And if
that's where we're going. So that means no indemnification can they get.
Can Omega?
There's no legal obligation for Omega to pay anything. No, I mean, so where's the indemnification? What comes from this after the settlement? I mean, that's out. I don't see how in the world you can say you got some right for indemnification. I don't get that. But the duty to defend is a past type thing that deals with the potentiality of the claims. That's an attractive aspect of it. But I don't want to push it too much, but it doesn't seem to follow me.
And if I may, I see I'm slightly over, but I just want to mention one thing. To the extent Covington wants to argue, when we're addressing the duty to indemnify, wants to argue before the district court that because the plaintiffs agreed via a settlement agreement to not enforce the judgment against Omega, thus Covington is somehow excused, they can make that argument. That's not the argument that was ever made. That was not a conclusion that was ever reached by the district court.
But I think what my friend Judge Wynn is asking you, is there element of mootness here that are we, I mean, are we just deciding this duty to defend without any sort of practical consequence at the end of the road?
I don't agree with that. Real money was paid by Omega below due to the absence of a defense, due to the deck action that was filed by Covington. That is real money out of pocket.
Are they trying to enforce that?
Well, among the damages would be the money that Omega paid out of pocket relating to the underlying litigations and to the deck action, of course.
How much was that?
I don't have that number, Your Honor, and it's not part of the record.
So was there a counterclaim here? Because as I understand it, this is Covington's lawsuit
Correct?
seeking a declaratory judgment that they have no duty to defend or indemnify under the contract. And the district court agreed.
Correct.
If we were to reverse or vacate the judgment, we would simply be then you have no, as I understand it, you have no claim in this particular case that for indemnification or for defense. This is simply Covington's action for declaratory judgment.
Well, as a practical matter, if an insurer files a deck action and seeks a judgment that they have no duty to defend, and the district court says you're wrong, you do in fact have a duty to defend, that changes the entire universe of the underlying litigation. So the fact that there is no counterclaim, I think in most cases the situation we have here is the standard situation. That is, a insurance company files a deck action, whether they win or they lose. If they lose, then you have to proceed and defend the case. I agree.
But here there's no case to defend.
There's no case to defend currently. That's right. There was a case to defend when they went into court and filed their declaratory judgment action and moved for summary judgment. And the district court, in our opinion, got it wrong. There was a case.
But at this point, if there's no declaration, where does that leave your client?
That leaves my client arguing that in addition, that to the extent this court was to remand and said there was in fact a duty to defend and the district court got it wrong, then we're going to talk about whether or not there was a duty to indemnify. A, what does that duty to defend cost, i.e. what did Omega pay out of pocket? B, there's a $155,000 consent judgment to which we would argue Covington is on the hook for. That's the position. Now that issue is...
But you've made no claim for either of those payments in this litigation.
I've made no claim. I have argued at summary judgment that Covington has a duty to defend the underlying lawsuit. I have made that claim. That's the argument. The district court disagreed with me, but the absence of a counterclaim, effectively saying, Covington says we don't have a duty to defend, and Omega saying, here's a counterclaim, you do have a duty to defend. I'm not sure that changes the analysis concerning how this shakes out to the extent the district court was wrong and there was in fact a duty to defend. Again, Covington can make every argument it wants on the duty to indemnify on the $155,000 consent judgment. I have authority from around the country that says that when a duty to defend is breached and a consent judgment is not paid, the duty to indemnify has in fact been breached.
All right, well, let's hear from you on rebuttal on this. Do you have
Thank you.
further questions at this point, Judge Berner?
No, thank you.
All right, let's hear from Mr. Sims. You've got to unmute yourself, Mr.
I always forget to do that.
Yeah, no problem.
Good afternoon, Your Honors, and may it please the court. I'm going to step right in. I want to kind of clarify some issues on the record. First of all, there is no breach of the duty to defend. That issue was never asserted or raised that Covington was in breach of its duty to defend. In fact, the facts that were alleged, even to the point where in their opening brief, Omega acknowledges that when the initial complaint was filed up in Fairfax, it had a defamation claim. And the Covington issued a letter, a reservation of rights.
Let me just
letter.
make sure we are on the same page on this, because I want to ask the same question I asked at the beginning to your opposing counsel. regarding the potentiality matter here. Generally, there is a duty to defend and ensure that if there is any potentiality that you have some underlying claims that fall within the insurance policy. You have some explicit claims. I think about 4 of them is what I would say. You had 4, and then but there are possibly a couple of potential claims. It's settled, and the potential claims aren't there. But you got this pass of the duty to defend there. He brings up the defamation one, which is one of those potential claims here. And the question is, it's kind of murky to me. It seems like on the one hand, you've settled it, and that would have covered it in, but you got that duty to defend, and it will exist. If there's a potential claim, you should have the defendant that falls within the purview of that policy. And I think defamation by this implication would be one of those claims. And if that exists, you got this duty to defend. Then the question comes up, because we got murky into indemnification. I think indemnification is totally a separate question. I think it's 2 different animals out there. But I also think that the indemnification probably doesn't mean very much to me, because I don't think Omega has any obligation whatsoever. So, and you got to have it. Covenant doesn't independently have this. It has to come from somewhere. But the duty to defend question is the question that's bothering me, and the way in which it arises here. You would think common sense says it's settled. There's no claims there. All the claims are settled or whatever. But that potentiality element that comes into the duty to defend goes back to the past of what's there. Did you have a duty to defend there? And if we were to find the potentiality claim of defamation is included, then yes. Then it goes back, and the only thing is I guess attorney's fees or payment for the duty to defend.
But that's the point I was trying to make, Judge Wynn. We were providing a defense. We were providing a defense, and it's undisputed.
But that's a determination ultimately. If we say, yeah, you had a duty to defend, then if it goes back, you can say, well, we did that. We did that here, so you're not entitled to any defense. But here's a question. When did you stop defending? Is the question.
When they settled the case. It was.
So you're saying you fulfilled the duty to defend all the way through settlement.
Exactly. There was outside.
Well, then if that's the case, that I don't know. I don't see how you're going to be harmed if you send it back and say you had a duty to defend. You're going to go and say we defended. That's the end of it, isn't it?
The reason why we brought the case, and I brought the case on behalf of Covington, is we were providing a defense. We wanted to stop providing that defense. We wanted a ruling from the court that we didn't have to continue to provide a defense, because the initial defense letter was provided on a lawsuit that alleged defamation.
Counsel?
Yes.
Why isn't that a proper subject for remand? You say you had no duty to defend. The other people say you did have a duty to defend. And you say, well, we did defend, but isn't the question of whether you did defend, how long you defended, whether that Omega's on the hook for anything. I'm wondering if all of that isn't just an appropriate subject for remand, which will untangle all these questions. We're talking about, how much does Omega owe, and was there a defense, and when did it stop, and what are the terms of the settlement, and all the rest.
If I may answer that question.
Hold on a minute, please. Okay. Thank you. I'm just wondering why the only question before us is whether there was a duty to defend based on the complaint against Omega that was filed. Why isn't that straightforward question the only thing that's before us now, and all of these other things, the things we're speculating on, that would require further factual development?
Your Honor, my response to that is it was an undisputed fact before the court on summary judgment that the Covington was providing a defense. And the court, in its opinion, and this is at Joint Appendix 200, it's her opinion, she states that fact, that Covington is providing a defense under its reservation of rights. And that is the coverage letter where the reservation of rights is at Joint Appendix 121. And the plaintiffs themselves, in their brief before this court, when they assert the factual statements of the case, they state that we were providing a defense under the reservation of rights. And that's an appellant brief, page 6. So it's never been in dispute. It was never in dispute that Covington was providing a defense throughout the litigation. What it was seeking is a determination, as the court indicated, for the future. We wanted to stop having
Well,
to
that's
pay.
the point Judge Wilkerson is making, though. Your opponent said it is in dispute. They're saying, although the record doesn't really indicate when you stopped defending, you did start, but the simple answer is if we just send it back, we don't generally make those kind of factual determinations. We send it back and district court can make a determination. You can just get in there and show you defend it to the end. Seems like to me that's just a very short time in court. If you did, that'd be the end of it. If you didn't, then there'll be some assessment of, from that point. I mean, but
And here's the other issue. There's no, and I'll echo what Judge Berner said. There's no claim below. There's no claim of a breach of the duty to defend by Omega. They clearly could have asserted that, and I would say within the context of litigation, they were compelled to do that.
You don't have a claim of it until there is no defense. When you say there's no claim, I guess you were and then you didn't.
Well, we never
reverse the duty to defend, then he could go back and bring a breach of contract claim separately on that. That's what we're talking about. And if it goes back to this court, I mean, it doesn't sound like to me this is as complicated as it seems. It seems like to me it's pretty straightforward. Either you defended or you didn't, which is a factual determination a district court could make pretty quickly.
I will say, though, it is Hornbook law. I know that the understanding is the duty to defend is broader than the duty to identify. But if there is no duty,
Covenant is asking for its litigation costs in the two. I think they're asking for that. I mean, it just. I know we're going back and forth on this, but it doesn't seem like to me this is going to be a difficult situation if we determine there is such a thing as a duty to defend under this potentiality claim here, potentiality analysis where, yeah, for the beginning, because of defamation, it existed. Looks like to me it probably does. But even if it does, you say you don't owe anything because you defend it. That sounds like a zero damage thing to me. If you just go back to the court and deal with it, I don't get it. I mean,
I understand. I will say this with respect to the defamation claim. Okay, I understand you feel like that there might be some potentiality there. I think the court was correct in the analysis under Virginia law, and as is stated in the CACI case that Judge Wilkinson authored, in order, you have to find that you allege facts within the complaint that would make the insurer liable. And in the defamation context, okay, and what was only argued to the court by Omega in their motion opposing our summary judgment, in their counter motion for summary judgment, was defamation by implication. That was all that was alleged. Okay.
Excuse me, isn't there a striking difference between being a stripper in a strip club and being a professional model? And the professional models are filing a complaint, and they said that the association with Omega has sort of lumped them in with strippers. Now that would seem to me to be, pretty much in the heartland. It might be pretty much in the heartland of a defamation claim when you have professional models bringing a suit against Omega and say, well, the way you've used our image has implied that we are strippers, and we're not strippers. And you're accusing us of something that we are not. Now, that seems, I don't know how it would play out, but in terms of potentiality and everything, that seems to me a sort of a garden variety question of defamation, isn't it?
No, Your Honor, it's not under Virginia law. And I'll tell you, because what the court did is appropriately what you would do under defamation law. It is for the court, as the gatekeeper, to make the initial determination of whether or not the statement is defamatory. And when you look at the pictures, this is what's being communicated. Because remember, defamation relates to the statement that's being made. Right. So
that's the fundamental question, and that you really need to answer right now. And that is, does the court get to decide the merits of this, which is what the court basically said. It said, it doesn't look like it has much of a chance of success. I don't think that's the case with a potentiality claim. The question is there an allegation in this complaint that fits within an enumerated injury under the policy, and you got Section D that says defamation, and he makes the allegation. There's no exclusion from it. There's no waiver. I think that's the duty to defend. It doesn't, the whole business of, can he succeed on it, and were they really strippers, and did this happen? That's not how you deal with a duty to defend claim. So I think that, but I want to make sure we understand that's the fundamental question. But if you disagree, show me a case in which the court gets to look at the merits of it and determine potentiality, as opposed to the allegation is made and whether the policy itself indicates it, triggers the duty to defend.
I don't disagree. You're not getting into the merits, but this is about. Again, we're not dealing with an actual claim. So this is a potential claim, right? So they get a question. So they didn't allege this. They had it in an initial complaint. They took it out, right?
That's not going to matter, because the duty to defend arises when there is a potentiality situation. It's not going to matter, because when you look at the language that establishes a defamation claim, it's there. And then you look, does the policy include an enumerated injury? It's there.
It isn't. And I'll tell you.
But hear me out, because I want to make sure we're not arguing across one another.
Sure.
So that's because this is not an argumentative situation. It's really trying to understand your position on it. And I get where you're going, but I think that the trial court may have fallen in the same kind of situation. The trial court said, I don't think you got much of a chance of success. Well, you might be right. He's probably, but that's not going to the duty to defend. And that's where I think that's the fundamental difference in what we've got to parse out here. I think it's where Judge Wilkinson may have been going to some extent on it. And that is, the duty to defend arises because we don't get in this business of doing many trials on this. We're not doing this. We're only going to look to see if you got a duty to defend. Boom, the law says you defend if that potentiality claim is here and the policy has it, it's there. And so, but end of the day, I'll come back to what we said earlier. You said you defended. So I don't know what harm is going to happen if we say you had a duty to defend. When I say down the road, what is it going to take for you to go back and say we defended?
I will say that that's already been factually established. It's in the court's opinion that we defended. And when she wrote her opinion, and that opinion was issued.
Well, it goes back to my statement again. If we say it's a duty to defend, then it's pretty easy for you to go back. We send it back and says, there it is, we defended.
But I will say, I do believe that the district court did not do a merits analysis. What the district court did, and I think correctly did, was look at the factual allegations to see if they met the factual allegations of establishing defamation. You're putting somebody in an odious, nobody wants to deal with you sort of circumstance. Or that and it wasn't a defamation, they didn't argue defamation per se. They argued defamation by implication. They argued, and whether or not, I will tell you, in today's society, I hate to say this, but being a model, it may be being associated with a.
I think Judge Wilkinson is trying to ask you a
Can
question.
you hear me? Because you've repeatedly talked over me throughout this argument.
I'm sorry, I didn't hear that you were talking, Your Honor.
All right, well, I accept that. And that if you didn't hear me, then you didn't hear me. And I don't blame you for a second for being passionate about your claims. So we'll put that aside, no problem.
Thank you, Your Honor.
No problem at all. But the only question I have is, it seems to me that what Judge Wynn is concerned about and what I'm concerned about is that the duty to defend is a very, very broad one, as you've recognized in your own argument, and that the duty to defend goes to a question of potentiality. And then the question I have is, isn't it possible to say that the whole question of defamation is running through the underlying complaint against Omega, and what it is a lawsuit that is brought by professional models who feel that the use of their images by Omega put them in the classification of a stripper, and that that's not who they are, and that they have been professionally demeaned in an untrue way. Now, we can argue about whether this was exactly part of the complaint or not, but it certainly has the vibes of a defamation claim. That seems to me to be part and parcel of what the professional models are concerned about. Given the duty to defend extending to partiality, to potentiality, given that it's too broad, there just seem to be, in the result of these arguments, there just seem to be a number of factual questions about whether a defense was provided and everything, but only a little small preliminary part, as I see it, is before us here. That's just my concern. Before I pass on to that concern, I wanted to tell you, Mr. Sims, that I think I jumped on you too soon because you didn't hear me, and that is just completely and totally fine with me. I just want you to know what the nagging concern I have about this, that the duty to defend is broad, that it encompasses potentiality, that there are questions about this and that need to be answered down the road, including whether there was a defense. That's one of the questions. And if so, what the remedy is, and what the duty was. I mean, and how much, and what the remedy would be, and how much, if anything, is owed. And why can't we just focus on those preliminary points as the only thing that is before us?
Yes, Your Honor, I would say this. If the court is inclined to remand this case back on the duty to defend issue, I would ask the court to clarify that in terms of doing that in light of the judgment that was entered, there is no duty to indemnify. And that's clear under this court's decision in the Hitt case and the Stonehenge case. There's no question that there's no issue, no duty to indemnify. And I will make the point that what was agreed to, and it's we don't look at the settlement agreement. We look at the order that was entered by the court, because the order is, they specified that what they were consenting to was the 4 claims. That judgment was entered against Omega, not on potential claims, but on the 4 claims asserted in the complaint. All right. And the court's order makes clear that the Omega has no duty to pay that judgment. So there's no legal liability. And under that circumstance, there's no indemnity. And I would say it wipes out any duty to defend as of that point in time, right? You enter that agreement and
may I ask you this question, Mr. Sims? I've listened carefully to what you said, but if we decide that there was a duty to defend based on potentiality, would it have some impact perhaps on the on your view and the perspective that you take with regard to the duty to indemnify?
No, the duty to indemnify is based on, as you wrote in the CACI case, it's what happens, right? It's the facts. And in this case, Omega specifically admitted to a consent judgment on 4 counts in their complaint, and then walked away from any liability, any duty to pay on that liability claim. And our policy, Covington's policy, only provides coverage for a duty to defend, indemnify for a liability, a legal liability imposed on Omega. They have no legal liability to pay this judgment. And
I just want to be clear in terms of one point you make, but because I think it bears at least, I don't know if any more discussion on it, but I don't think we're arguing about anything that happened after the settlement in terms of a duty to defend. We're talking about matters that you had to pay for the defense before the settlement. Now, your representation is you defended it all the way through settlement, which is why I came back and said, well, why do you care if we said you had a duty to defend if you did the defense? Because sounds like to me that's not going to be a problem. So you were going okay until you got into the business and I don't think there's a duty to defend. I don't think you have to go there, because we're not talking about a duty to defend after the settlement. We're talking about the duty to defend, the settlement up to the time of settlement. So that's the clarification.
And I'm way past my time, Your Honor, unless anybody has any other questions.
Judge Berner, do you have a question?
Oh, thank you.
All right. Mr. Golozewski, would you please give us your rebuttal?
Thank you, Your Honor. On this last point, the notion that this court, if it's so inclined, should remand the matter, but with an instruction that there's no indemnification, which is an issue that has never been briefed.
Answer the first question there, though.
Sure.
When do you say they stopped defending? Or did they defend this matter all the way through the settlement?
They absolutely defended this matter for a period of time.
I got that. I want to know, when did they stop?
I want to be clear.
When do you maintain they stopped? Because only then would you be entitled to damages for that portion you said they stopped until the time of the settlement.
I don't disagree with that, but I may also be entitled under Virginia law, if I win on the duty to defend, that is, if this court says there is a duty to defend, I may very well be entitled to the fees incurred by Omega fighting Covington on that deck action. That is a potential. It's not a mandatory, but it is a potential claim for fees that Omega.
So answer my question. Did they defend this matter all the way through settlement?
Again, Your Honor, I was on the other side of the V at that point. I don't know exactly. They absolutely defended for a significant portion of time. I am not going to dispute counsel's representation.
It seems like somebody would know that. If you're saying you had a duty to defend on the other side or whatever side, it seems like somebody would know. If they defended it all the way through, then why bring a claim for a duty to defend? Because they defended it, the thing.
I understand, Your Honor, and I think Your Honor's point, which is that, well, if they defended, there's going to be a timesheet that says up until this date they defended, and it's going to be a very quick and easy evaluation by the district court. That's not the question that's before.
So you're telling me it's a question of fact, because you don't know, and even though he represented that, you just don't know when the duty, when they stop defending. Seems like to me you would know, but I'm gonna leave that alone. I just wanted to know that. That was curious to me because I think, at least in my mind, we're talking about the duty to defend before the settlement.
We are.
And he says we defended it all the way through, so that would end it. But I would, let's leave that alone. You go ahead and talk about your indemnification, because I think that's really what you really want to talk about.
Well, what I wanted to say is that I don't think there is, with great respect, I don't think the court can issue an order when all that's before the court is the duty to defend, that the court says, we agree, the district court erred in held there's a duty to defend. Oh, and by the way, there's also no duty to indemnify, although there's a duty to defend. I don't think the court can do that. That issue was not before the district court. All that was before the district court, because the underlying litigation was ongoing at that time, all that was before there was the duty to defend. That is a pure...
Who has the duty to indemnify? What entity?
We're going to argue that Covington has the duty to indemnify. Absolutely.
And it arises from...
It arises from the
who
fact...
Who has the obligation? From what indemnify what obligation?
There was a judgment, and a valid judgment entered against Omega.
And does Omega have anything that it's obligated to do?
Omega entered a settlement agreement pursuant to which the Geiger plaintiffs agreed not to enforce that judgment. It doesn't mean there's not a judgment against Omega. It's there. It's there.
If a plaintiff agree not to enforce a judgment, then what is the judgment? I mean, what good is a judgment if you're not going to enforce it? I mean, I practiced law for a long time. I had a lot of judgments. You couldn't get them, so they were worth nothing. But you have a court order saying that they will not do it.
No.
So they will not do it. If they don't enforce the judgment, who can?
No, Your Honor, it doesn't say we won't enforce the judgment. It says we won't enforce the judgment vis-a-vis Omega. That's what it says. It doesn't say anything about whether or not I can try to enforce that judgment against Covington. It says nothing whatsoever about it. That is a valid judgment that is on the books at the district court. Now, there is a separate settlement agreement, a private settlement agreement between individuals and Omega, which says, you know what? For giving us the right to go against Covington on the deck action and for the assignment, we will agree not to enforce that against you. That is a separate analysis. Look, I understand Your Honor's point, and I understand counsel's point, and I fully anticipate them to make this argument. But again, that's not the question that's before this court right now. Let them make that argument before the district court. We didn't even get
Does Covington have an independent obligation?
Covington,
or is this obligation dependent upon whether Omega has an obligation?
Omega does have an obligation. Omega has a legal obligation which has been excused via a private settlement agreement.
That's my point. I understand that. But does Covington have an independent obligation?
I think Covington does have an independent obligation. There's a judgment against its insured. There is a judgment that has been entered against its insured.
Tell me the case that supports where you're going with this.
I have a case, Your Honor, from 2024 in the District of Rhode Island, which says
what you just said.
Your Honor, if I may present it via letter after this argument, which says
where's the case coming from?
The District of Rhode Island, the Chief Judge McConnell in the District of Rhode Island, which said...
I know you got to do a little better than the District of Rhode Island. We don't even want a case from a district in the Fourth Circuit. We want you to give us a case. Even a circuit court case is not binding on us. It would be some guidance. But you got to give me something a little bit more than a District of Rhode Island case. No disrespect to the District of Rhode Island. We can look at it, but in terms of if we have not done it. But I'm just saying, is that it?
That's what sprung to mind to answer Your Honor's question, which said the duty to defend has been breached, the consent judgment has not been paid, thus the duty to indemnify has been breached, and thus the insurance company is on the hook for that. And to be clear,
you're very forceful in it, and I got your point, and maybe there's some nuance in that language you can read in it, but I think at the end of the day, I think we can all agree Omega will never have to pay anything. There's no legal obligation for Omega to pay a single penny
I will submit that after. If I may make one last argument, if it would be acceptable. I see that my time is up. Just the last thing. Counsel made the point that we didn't argue.
Be very brief, all right?
I will. Counsel said we didn't argue, quote, argue defamation per se. And I just want to point out the allegation, quote, plaintiffs allege that any improper or unauthorized use of their images substantially injures their careers. That is a defamation per se allegation. With that, Your Honors, I appreciate your time.
All right, we thank you. And we will adjourn court for the day. And I will ask our good courtroom deputy to clear the courtroom and let us conference confidentially. And I want to thank both counsel today for their arguments and how much the court appreciates your presentations. Thank you both.
Thank you, Your Honor. Thank you.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.